Item number
Actually, we should have had judgment first. He's not aware. You have to read our criminal appeal number. It's not just item 1.
CRA 207/2000.
The appeal is dismissed. The appellants are directed to surrender not later than 20th September.
Item 2 JCRL 118/2005.
The appeal is dismissed. No order. To surrender by 19th.
Weekly Delhi for judgment. Item number 1 GA 17/9091.
The appeal is dismissed.
Item 2 JCRL 1-14.
The appeal is dismissed. The appellant is directed to surrender 14th and in any event not later than 20th of September 2022.
Item number 3 JCRL 67/2015.
The appeal is dismissed.
My lord, dismissed.
Yes.
Gratefully lodged.
Item number 4 CRLA 118/2022.
The appeal is dismissed.
All matters. Item number 5.
Pardon, my lord. I not placed, my lord.
Not rest dismissed.
Lord, I am appearing on behalf of OP number 6.
Or
Not yes.
Item number 6.
My lord, the writ appeal was filed by the university, assailing the direction issued by the Honorable Single Judge directing to regularize the admission of the petitioner in excess of the intake capacity sanctioned AICT. Whereas in the meantime, we have decided to regularize his admission that is there. I have passed on the letter, my lords, subject to the cooperation by the student that he produces all the records before us.
all right.
So it doesn't, this
Mr. Pale,
reason does
Senior
not
Counsel
survive.
for the appellant has produced a copy of a written instruction received. Copy of a letter dated 30th June 2022,
Mal, so
written by the Director Examination Charge to the respondent, requiring him to submit all the original documents and against his claim on appearance of various examinations, including publication results, within 15 days. In view of the above development, the appeal is disposed of
Mal,
as having become effective.
obliged.
Item number 7.
My lord, item number 7, we have no instruction.
No instructions disposed of.
Okay.
Item number 8.
May I please lordship? My lord,
Yes, please.
my lord. My lord, the petition, the appellant, my lord, you challenge the order of single judge as well as the order, my lord, of the appellate authority, where, my lord, as an Anganwadi worker, pursuant to advertisement, my lord, I was selected. Annexure 1 to the my writ petition, I was selected. Annexure 2, I was given appointment letter. Thereafter, what happened, my lord? Opposite part number 3, respondent 3 challenged the my order before the appellate authority. Appellate authority, my lord, without taking into consideration of the guideline, I, my lord, rejected my application, my candidature, and directed to give the appointment in respect of the respondent 3. I have secured 49 marks, and no doubt respondent 3 has secured 50 marks. But as per guideline, my lord, the person who have to select, she or he belongs to of that area. Guideline clear says that annexure 1, your lordship will find selection list I was belong to that selection area, my lord. The OP3 not belongs to outsider. Guideline strictly says, Annexure 3, your lordship will find the guideline of the government. And counter filed by the government also, my lord, admitting that the appellant, myself, is belong to that area and I was selected. Government was filed counter in the writ petition. My lord, single judge taking into consideration the counter as well as the guideline, dismissed my writ petition and allowed the appellate authority order. Whereas I was selected, I was appointed, I was joined. Thereafter, OP3, my lord, filed the paper of appeal. You will also find the Annexure 1, the selection list. And have a glance the Annexure 1 of the writ petition, my lord. My lord, writ petition, page, Annexure 1, page 7, my lord.
Yes.
My lord, my name is serial number 2. Bilasini Behera, and last person remarks later selected. You know, simply fine.
Yes, yes, carry on, sir.
My lord. And the OP3, my lord, whose name stands as serial number 1, its remarks column is that out of Anganwadi Center, AWC area. My lord. But you will also find she has secured 50 marks, I have secured 49 marks. And serial number 19, it had mentioned RV. It is a RV matlab milad, revenue village. But AWC similar belongs to Anganwadi Center. Guideline specifies that it is a honorary post. It is not a promotional post. So the person who belongs to Anganwadi Center area, he will be or she will be selected. And in pursuant to Annexure 1 selection list, Annexure 2, I was given appointment. At page Annexure 2, serial number as running page 11, serial number 16, my name is there, I was selected. And I was joined and continued. Thereafter, and Annexure, lordship Annexure find Annexure 3. Only you have to find out Annexure 3 the guideline. Guideline, I have to say, my lord. Guideline, Annexure 3 at page 12 up to my writ petition, my lord. In guideline, page number, next page number 13, my lord. Serial number 1, it has mentioned application for selection of volunteers to work as Anganwadi worker will be invited for each village Anganwadi Center area from women residing in said village stroke Anganwadi Center area. And to clarify,
Sir, you have to unmute yourself.
this, my lord, at page 18, government has clarified, my lord. At page 18, government has clarified. You let me do the vital, kindly have a glance. At page 18, Annexure 3 series. I am reading out, my lord. This is the notification dated 9/4/10. It has clarified, in case woman is found eligible from those residing in service area, then women from the other parts of the same village will be considered. If no woman is found from village of the Gram Panchayat will be considered. My lord. So I was selected and I belongs to Anganwadi area center. And my lord, the guideline is there and counter will also be filed. Counter filed by the government. And it's at page, my lord, you will also file OP2 has filed counter. At page para 8 of the counter. Clarified that, my lord. I am reading out of the counter of the government, my lord. They have clarified only that OP, myself, the applicant, or the serial 5 was they are coming under zone of consideration. Those 2 persons only they coming under the zone of consideration. And I out among of 2, the appellate, myself petitioner, secured highest mark, I was selected. This is the case, my lord. But the honorable single judge, without considering, my lord, the guideline counter filed by the government, stated that the appellate authority has correctly passed the order.
No, just read the order, sir. Now read the single judge's order.
My lord. Yes, they have categorically quoted the order of the appellate authority. The only, my lord, the single judge has quoted, yes, considering the contention, the learned counsel of the parties, and on perusal of the impugned order, it appears that petitioner who is a resident has appeared and impugned order was. And now, on perusal of the record, the appellate authority has considered the survey report submitted by the lady supervisor concerned The report was neither prepared as per guideline of the government issued Women Child Development Orissa, nor approved by the CD. Well, it is that it has been stated by the appellate authority.
Kindly read on.
Yes. The report was neither prepared as per guidelines of the government issued Women and Child Development Orissa, nor approved by CDPO. Therefore, the survey was not accepted to determine the residence of the applicants. The select list was prepared by the selection committee on the basis of survey report. Yes, my lord, that is vital. And in remarks column, it was reflected reside out of the Anganwadi center area against OP3. OP3 belongs to out of area, my lord, no doubt. And one Janamani Behra. Since the survey report was not accepted, and on the basis of survey report, candidature of the more meritorious candidate was not rejected. Adopting pick and choose method, the authority selected less meritorious candidates. On the above grounds, the appellate authority set aside the engagement order and directed CDPO to issue an engagement order. Yes, that is my case. That is my case, my lord. That survey report is given by the selection committee. How the appellate authority find that survey report is not approved? And the selection committee is there. There the chairman, vice chairman, sub-collector there. They have selected. And the appellate authority who said that the survey is not accepted. It is not approved. This is the case, my lord.
Because here the single judge has rightly pointed out that since the survey report is not authenticated, has not been submitted by the lady supervisor as per the guidelines, so therefore the survey report cannot be taken into consideration. And hence, my lords, the remark that the respondent number 3 here is out of the AWC area cannot be considered. And concurrent findings, the appellate authority has also remarked the same thing, that since the survey report is wrong, so therefore that cannot be considered. And she admitted cases that she has secured more marks than the petitioner here. So therefore a meritorious candidate is being.
Sir, admittedly, you got 49, the other candidate 50, correct?
My lord, I admit.
She's definitely more meritorious in that context.
My lord, then, my lord, serial number 6 has got 59 marks. Then serial number 6 got 15 marks. She should have been given. My lord, kindly appreciate. Then, if I got 49, I have rejected, and OP3 has got 50 marks. But serial number 6 has got 59 marks. Then she should have been given. Why OP3, my lord? This is the criteria of the guideline. The person who will be selected from the belongs to exactly what is center area. This petitioner belongs to that area. Otherwise, the OP6 should have given. The serial number 6 of the selection list you will find, she has got 59 marks. Kindly appreciate, my lord. Only question that serial number 6 of that selection list, she has got 59 marks, my lord. And you'll also find in the selection remarks column, she also belongs out of area, Anganwadi area center. That's why her case was rejected. My lord, kindly appreciate, my lord. I was duly selected. And a guideline is again you'll also find the guideline. Guideline strictly says and clarified to that effect again by the government of Odisha. And counterfile the state also now they are denying, but filed in the writ petition. They are admitting that petitioner belongs to Anganwadi area center and she could have had marks. Only 2% coming under the zone of considerations. That's why the serial number, the 6 of that selection list was rejected. She was obtained 59 marks.
All right. We'll reserve orders. Orders reserved.
And there are those the decisions are there in favor of me. I have given in the my lord. So single judge decisions also there. There's my lord honorable single judge also not considered. This is a reported. I have mentioned that reported judgment 2002 OLR 188. Clear exactly same case, my lord. Where honorable single judge has decided the person belongs to Anganwadi area center, that's her candidature will be considered.
All right.
Obliged.
In this case, I am appearing for the OP number 3. Here in this case, he's belonging to another Anganwadi center area where another Anganwadi center is there, Runivasa 1. I am belonging to Runivasa 2 where advertisement has been made, my lord. And I have also secured, my lord, marked than her, and to that effect, my lord, inquiry wrong. They have put an inquiry. Subsequently, inquiry report was wrong. Therefore, the learned my lord, ADM as well as the learned single judge rightly my lord, rejected the my lord, case of the appellant my lord, and I was selected. I have also secured more mark. Another Anganwadi center is there in there. He is belonging to ward number my lord, ward number 5, where another Anganwadi center is there. I am belonging to ward number 6, where this Anganwadi center is there my lord. And to that effect, Sarpanch and everything has been reported to that effect. That was also taken into consideration at that point of time. My lord.
Where is that? Before selection.
Follow the next matter.
Item number 9.
Oblige, my lord.
None appears to cease in opposition.
Item number 10.
Item 10, Lordship, is here is very simple, Lordship. Admittedly, on the land of the petitioner, they have constructed a community hall. Lordship, at this stage, Lordship, may direct to collect to take a decision, Lordship, because the report is there. There is no dispute that they have constructed the community hall in my place, Lordship, in my recorded land. So, matter 2013, Lordship, direct to collect to take a decision in this matter, Lordship.
No, there's a judgment of the learned civil judge.
Lordship, but on a flimsy ground, Lordship, because 144 proceeding was pending before some court, that's why it is rejected. But the admitted case of the petitioner, the government has constructed a community hall in my recorded land, Lordship. Only as per law, I will get compensation. At best, I will get compensation. So it can be considered by the collector.
No, what is it? When was all this when did all this happen, sir? Which year? There is no stay by this court.
No stay.
So when did all this happen? How can we now permit you to make a representation?
No, not representation, I'm saying, Lordship. They are, in the case of the opposite parties, the revenue inspector has given a report that they have constructed a community hall in my land.
So when was this construction?
Lordship, in 2013, Lordship, that is there.
So what?
So, Lordship, I am entitled to get the compensation only, Lordship, if at all. So that may take a decision.
No, there must be a law for that.
Yeah, that is the law of land acquisition or not. Law of land acquisition is there, Lordship.
No. So you have to go in an award. If there's an award.
They have not acquired the land at all, Lordship.
Then where's the
For sure, they have
land acquisition proceedings?
No, they have not restricted. The state government.
Then you file a civil suit, sir. If according to you, on your land, they have built a house.
How can the state will make the arbitrary power, Lordship, will they forcibly construct land in my house, Lordship?
Yes.
When the law is available,
right.
Land of acquisition, law of land acquisition is there.
Right.
So Lordship only say Lordship because the Lordship kindly see with their own admission. The RI has given report. They have admittedly constructed residential community hall in my land. Only relief to me, Lordship, I will file a...
What did the single judge say? Let's see that.
Lordship, single judge only because the CR 144 proceeding is pending. That's why she is not entertained, Lordship. Lordship, kindly the order of the honorable single judge. At page 33, Lordship. And Lordship got it, page 33.
Page 41.
41, sorry, Lordship. On perusal of the records, it appears the revenue inspector submitted a report before the Tahsildar Olanda, stating therein that the construction work of the community has been stopped due to initiation of proceeding under section 144. So at the relevant time, it was stopped due to 144 proceeding. Yeah, my claim cannot.
Has it now been constructed? Are you aware?
Lordship, now, my lord, they have constructed, Lordship. That is my information.
How do you know? Then you make a fresh representation.
Yeah, Lordship.
Cause of action is changed.
Lordship.
Counsel for the petitioner states, due to subsequent developments, the present writ appeal has been rendered infructuous. However, he reserves the right to make a fresh representation in case any cause of action survives. Reserving the liberty is prayed for, the writ appeal is disposed of.
Item number 11.
Lordship.
No instruction, my lord.
No instructions disposed of.
Item number 12.
My lord, for condonation of delay, this case is filed. And 1 week time may be given for removing the defects.
Not now, sir. This is a 2013 matter.
Just 2-3 days can be given for removing defect.
It's a 9-year-old matter, sir. We're not adjourning it.
A similar batch matter mallet has been disposed of by this.
Sure.
Is there. Submission. In another case, my lord, in a batch case, my lord, that EPF matter, writ appeal preferred by the EPF authority.
Yeah, you say in view of the order dated 26th August 2015, in writ appeal 431 of 2013, the present writ appeal is also dismissed. The contempt petition is disposed of in view of the order passed today.
Item number 13,
Then appears dismissed for non-prosecution.
item number 14,
That's item 14. Both are writ appeals against interim orders of the Honorable Single Judge. With
Repetition is
efflux
disposed
of time, this
Correct.
can
Both
nothing
these
further
writ appeals have
remains.
been rendered infructuous due to efflux of time. They are disposed of as such.
My lord, I am on behalf of Mr. Pagit for OP number 4.
For OP1, I am appearing, Your Lordship.
Correct.
item number 15,
Then appears dismissed for non-prosecution.
item number 16,
Then appears dismissed for non-prosecution.
item number 17,
17, my lord, in the meantime, the order has already been carried out.
Correct. Counsel for the appellant states that the impugned order has been implemented. The appeal is disposed of as infructuous.
item number 18,
Then appears dismissed for non-prosecution.
item number 19,
Same order.
item number 20,
None appears dismissed for non-prosecution.
20, my lord, infructuous.
Infructuous disposed of. The connected petition is also disposed.
item number 21,
None appears dismissed for non-prosecution.
item number 22,
Item number 22, may I please, my lord. I have given a short chart, my lord. Colleague is there. Still, my lord. In this case, my lord, I have preferred the writ appeal challenging the order passed by the Honorable Single Judge, my lord, at Annexure 5, my lord. The short facts of this case, my lord. In this case, my lord, the respondent number 6 married in 2004 and lived with her husband in Noyagarh district, my lord. I have also given the voter list of her husband, my lord, that was annexed in the writ petition, my lord. Thereafter, in 2009, my lord, respondent number 6 obtained a resident certificate, my lord, from the concerned Tahsil office for service purpose, my lord. In 2009, my lord, under Annexure 1, a notification was issued for appointment of Anganwadi worker, my lord, in Jagannath Patna Anganwadi Center, my lord. Subsequently, the resident certificate issued in favor of the respondent number 6, my lord, that was cancelled by the order dated 15/12/2009, my lord, by the concerned Tahsildar on the ground that that was erroneously issued and she is residing with her in-laws in Noyagarh district and she is not belonging to this place, my lord. On that ground, the resident certificate was cancelled, my lord. Accordingly, she was not selected and I was selected, my lord. The appellant was selected and got appointment, my lord. But challenging such appointment, my lord, the respondent number 6 preferred an appeal before the concerned of appellate authority, my lord, which was also dismissed by order dated 5/6/2010, my lord. The appeal was dismissed. Thereafter, my lord, in 2010, the respondent number 6 preferred a writ petition, that is WPC number 2220 of 2010, challenging the cancellation of her residence certificate, my lord. And that writ petition was disposed of, my lord, with an order to consider her application afresh, my lord. In that writ petition, I was not a party, my lord. Thereafter, my lord, a fresh residence certificate was issued by the same Tahsildar who had cancelled it, my lord. That residence certificate was issued in the year 2011, my lord. After issuance of that residence certificate, my lord, again, the respondent number 6 filed another writ petition, my lord, before this honorable court, that is WPC number 26497 of 2011, challenging the order passed by the appellate authority, my lord, in rejecting her appeal in 2010, my lord. And that writ petition was disposed of with a direction to consider it a fresh, my lord. Thereafter, my lord, the authority, my lord, allowed the appeal by the Annexure 4, that is page 12, my lord. May be permitted to place that up, my lord. That is page 12, Annexure 4, my lord.
Yes.
My lord. May I place, my lord?
Yes, please.
My lord. The case is taken up today. had the learned counsel for the appellant respondent perused the memorandum of appeal filed
No,
by
just read the
appellant
just read the relevant portion, sir. Not like this the whole order. Just read the relevant portion, the reasoning.
The second paragraph, my lord. During hearing, the learned counsel, the appellant submitted that the application of the present petitioner, Srimati Madhupriya, was not considered on the ground that the residence certificate issued by the Tahsildar Jagannath Prasad was cancelled, but subsequently the same Tahsildar has issued the residential certificate to the petitioner by Miss case number such and such. He further stated that this matter was raised before this in WPC number such and such, and in order number 2 dated such and such, the Honorable High Court has passed the following order. Then we'll also may come to the next page, my lord.
Yes.
Next page, third paragraph, my lord. Second paragraph, sorry, second. Learned counsel for the petitioner has drawn the attention to this court the order of Tahsildar Jagannath Prasad dated 10/2/2011 as per Annex of 6 series, wherein the Tahsildar has the petitioner to be a resident of the village Jagannath Prasad and a fresh residence certificate has been issued to her by Miss case number such and such. Then the last portion, my lord, with next page, the last portion, my lord, which starts, my lord, that is the page 13, last paragraph, it starts, my lord. That I'm important to place, my lord. Since the Honorable High Court had set aside the order of the Sub-Collector of Bhanjanagar passed on 5/6/2010 in Miss case number 51 of 2009 and remitted back the case for fresh consideration in view of issue of residence certificate in favor of the petitioner, I am of the opinion that the present petitioner shall be treated as a valid candidate for the post of Anganwadi worker for Jagannath Patana of Jagannath Prasad ICDS project, and accordingly the selection committee is also directed to consider afresh the case of the present petitioner, Srimati Madhupriya, as per the guideline issued by the ICW and CD department by letter number such and such, and the letter dated such and such 9/4/2010, which provides the candidates of the central area should be considered first for the selection, and then from the other part the same village, and this then women from other village, and accordingly the committee who secures highest percentage of marks shall get the selection, shall get selected, my lord. After that, my lord, my humble submission before your lordship is that initially the residence certificate was cancelled by the same Tahsildar, my lord, on the ground that she is not residing in the village, and after marriage in the year 2004, since 2004, she has been residing in Noyagad district, my lord. But instead of preferring an appeal, she preferred a writ petition challenging the cancellation of her residence certificate. Thereafter, that was disposed of with a direction to consider a fresh. But when there is no change of circumstances, my lord, the said Tahsildar issued another certificate on the basis of which she challenged my appointment, my lord. By that time, I was working 2 years, my lord. And my appointment was challenged before this in the appeal, which was also dismissed in 2010, my lord. That is Annex of 3, order dated 5/6/2010, my lord. On the ground, it was cancelled, dismissed, my lord, that she belongs to another district and she is not a permanent resident of the center area, my lord. Subsequently, my lord, challenging this order, I prefer the writ petition before this honorable court. And this honorable court had order dated 24/9/2013, my lord, that is under Annex of 5, my lord, dismissed my writ petition on the ground that in view of Section 6 of the Hindu Succession Act, my lord, since the daughter is having a co-personary right over the property, application or her candidature is a valid. My lord, that order, it starts from page 15. It's from page 15, Annex of 5, my lord. And the relevant portion, my lord, page 18. I may be permitted to place, my lord, page 18, paragraph 8, my lord. At the outset, in view of the amendment of Section 6 of Hindu Succession Act, the daughter has become co-personer of the co-personary. The learned counsel for the petitioner didn't argument on the question of permanent residence of the petitioner. Thus, that is treated to have reached its logical end. However, in course of hearing, the learned counsel for the petitioner argued by advancing submissions. Firstly, it was submitted that the process of selection of Anganwadi worker restricting the applicants of Anganwadi service area is violative of Article 16 of the Constitution. Secondly, it is contended that in the alternative, the process of selecting the candidate who remains to be the only valid candidate, valid applicant by excluding others on some ground or other is not a selection, and therefore such selection is vitiated, my lord. And thereafter, my lord, paragraph 9, I may be permitted to place, my lord. As far as the first contention is concerned, the petitioner having applied for the post of Anganwadi worker in pursuance to the pursuance of the advertisement issued cannot be challenged the validity of the same after being successful in the selection, my lord.
That's correct. That's correct.
Here,
That's
my lord.
correct proposition, sir.
Here, my lord, I want to pause for a moment, my lord. Here, I was selected, my lord. Here, I was selected. I was engaged, my lord. Thereafter, my engagement was cancelled, my lord.
All right.
So, question of non-selection doesn't arise, my lord. Here, I was selected initially, and her candidature was rejected on the ground that she doesn't belong to this center area, my lord, and she is a resident of Noyagarh district, my lord. Because after marriage, she has been residing with her husband there, my lord, in district, which is all totally separate district, my lord.
Yes, what do you say?
Well, as the guidelines and factual submission, the guidelines say that the age limit, my lords, is 18 to 42. My lords, as on date, my lords, the petitioner is 43.
Oh, I see.
Because
So anyway, cannot get the employment.
Anyway, my lords.
My lord, I was working, my lord.
No, now you cannot, sir.
Because she has been disengaged.
Now the maximum age is crossed.
My lord, when I was working, if your losses hold that the
There is no interim order, sir.
illegal, my lord, I will be reinstated.
You're already 43. By mandamus, you can't be asked to be put back.
My lord, that is for the initial appointment, my lord. But here I was working and subsequently disengaged, my lord.
No, in this post, you're retired. The maximum age can be only 42.
Maximum age of initial appointment, my lord, it is 42. Here I was working, my lord. I was within the age limit. I was working. I was allowed to work. I was issued with a valid appointment order.
That's all right. That's not for long, sir.
2 years, my lord.
It's all subject to
I'm
outcome of the
appearing
petition,
for
obviously.
opposite party number 6, my lord, and she's continuing. My instruction is that she's continuing in service as well.
No, that is okay. That's your client.
Fine.
When I was working with a valid age limit, subsequently I was disengaged on the ground that her candidature is will be treated as valid and her candidature will be considered, my lord. Thereafter, I was disengaged, and the age limit which was pointed out by my learned friend, my lord, that was for the initial appointment, my lord. Unless unless that is the I secure the age limit, my lord, I cannot be considered for the for participation in the advertisement, my lord. Here I participated in the advertisement, participated in the selection process. I was selected, my lord, and I worked for 2 years. Thereafter, I was disengaged.
All right.
It belongs to
orders reserved, sir.
Item number 23.
None appears dismissed in opposition.
Item 23, it is an infructuous matter.
Infructuous disposed of.
Item number 24.
None appears dismissed in opposition.
Item number 25.
Item number 25 to 29. Your lordships, not writ appeals, your lordship dismissed on the ground of delay. There is delay of 560 days.
All right. There's a delay of unexplained delay. Not it an unexplained delay of over 500 days. The delay is accordingly not condoned. Consequently, the writ appeals are dismissed.
Item number 30.
May I please? My lord, kindly have a glance to the impugned order, my lord.
Yes.
At page 16, my lord. May I read out, my
Yes,
lord?
please.
Yes, my lord. Considering the contention raised by the learned counsel for the parties and on perusal of the materials available on record, it appears that Mahanadi Coalfield Limited issued requisition by Annexure 1 inviting applications to fill up the post of dumper operator training, having requisite qualification as per subclause 2 of the clause B. It stipulates that candidates having minimum 3 years actual driving experience of the highway, rear dumper coal haulers or hauling capacity of 35 short ton or above are only eligible to be considered for selection. The employment exchange, taking into account that the petitioners have 3 years of experience, recommended their names to the Mahanadi Coalfield Limited authorities for consideration of their selection as dumper operator training. But on scrutiny, it is found that the petitioner have not possessed 3 years experience as required after attaining the age of 20 years. When the petitioners were not selected, they have made grievance before the authorities, and the Mahanadi Coalfield Limited, by order dated 28/9/2009, stated that the petitioners have not 3 years of experience, therefore they have not been selected. Mr. Mahanti, Learned Counsel for the petitioners, referring to Annexure 11, states that Employment Exchange has clearly stated that the petitioners have got 3 years of experience, therefore their cases could not have been ignored by the authorities, which read as follows. That have been written, my lord. On perusal of Section 4(2) of the MB Act, it appears that no person under the age of 20 shall drive a transport vehicle in any public place. Therefore, the persons having 3 years experience after attaining the age of 20 years are only eligible to get license to ply heavy vehicles. The dumper operator is coming within the meaning of heavy vehicle. Therefore, one must have attained the age of 20 years to ply such vehicle. In addition to the same, as per the requirement of the advertisement, the petitioners must have 3 years of experience for consideration of their selection to the post of dumper operator training. Mr. N.C. Saul, Learned Counsel for the opposite party, number 1 and 2, referring to paragraph 6 of the counter affidavit, strenuously asked that since the petitioners don't satisfy the requirement, they have not been selected to the post of dumper operator training by the authorities. Considering the above, since the petitioner having no requisite qualification as per the requisition sent by the authorities to the Employment Exchange, read with Section 4(2) of the MB Act, they have not been selected. In view of the matter, the writ application merits no consideration. Accordingly, the same is dismissed. My lord, kindly have a glance in order to substantiate, my lord, those documents which have been overlooked by the learned single judge, my lord. My lord, kindly have a glance to the certificate which tells that the petitioners were having 3 years experience, my lord. My lord, kindly have glance to the writ petition.
Yes.
My lord, page 20.
Yes.
That is pertaining to petitioner number 1. By 93, he is 23 years and he is having 3 years experience, my lord. My lord, thereafter, page petitioner number 2, my lord.
Yes.
That is for the period of 3 years, my lord. My lord, thereafter, petitioner number 4, page 24. Annexure 4 series, page 24.
Yes.
My lord, that is 29 years. And my lord, and petitioner number 4, page 26. 21 years, my lord.
Yes.
My lord, kindly have a glance to the grievance petition which
Yes.
were submitted before the authorities and in what manner they have rejected, my lord. That is at page 34. Annexure 10. My lord, in all cases of the appellants, it is being written no less than 3 years of experience. And my lord, I have substantiated with the documents that the appellants were having 3 years experience by the time of when advertisement published, my lord. But in the counter, they have improved their stand by stating that the appellants were not having the valid driving license, my lord. And my lord, kindly have a glance to the requisition which was sent by the Employment Exchange at page 36.
Yes.
That is the, in inviting a reference to the letters on the subject noted above, I am to inform you that all the 4 petitioners, namely Ashok Kumar Maharana and others, have got 3 and more years of experience as ascertained from the records available in this office. My lord, this was the only bone of contention. My lord, but in the counter, they have developed their stand by stating they don't have a valid license, my lord. My lord, and the learned single judge has not taken into consideration all these facts. Though the learned single judge mentioned about the Annexure 11, but he had not given any suggestion or any remarks on that point, my lord. But on the basis of paragraph 6 of the counter, That is about the selection committee, my lord. They have rejected my writ petition.
There has been no interim order here.
No, my lord, I have referred, my lord, kindly have a glance to my WA.
Yes.
That is at page 19.
Yes.
Still poster lying vacant, my lord. That's why
That's all.
it is clearly there, my lord. At page 18.
Yes.
IB Valley dumper operator, my lord. Existing MP as on 139 and sanctioned MP, my lord, 219.
Yes.
Still poster lying vacant, my lord.
Yes. Who's for the state?
My lord, MCL authorities.
Mr. Devraj Manti. Can pass it over once, ask Mr. Manti to come. Devraj Manti.
Okay.
Item number 32. Item 31.
None appears to be in opposition.
Item number 32.
Item 32, may I please? I am in virtual membership.
Yes.
In this case, while my repetition is pending for my Annex 2 is pending. There is a present petition number 1 is a ward member of ward number 1, ward number 10 of.
You make a fresh representation if any cause of action survives.
My lords, obliged.
Permitting the petitioner to make a fresh representation to the authorities, and after following up, if any cause of action survives, and if after following up on such representation to seek appropriate remedies in accordance with law, the petition is disposed of.
My lord, I am appealing for the opposite petition 3. I am appealing for the opposite petition 3.
Okay.
The state petition.
Withdrawn. Memos.
Item number 33.
In this case, this PL.
No. In 30. Sir, you are appearing in which one, sir? Mr. Dash? In 32 or 33?
I am appearing in 32. 32.
32, there is a memo.
Yes, sir.
30. All right.
In this case, 33. 33 million.
33.
In this case, one advocate of Banjam Badasan file is PIL for direction for proper administration of all Hindu religious institutions of the Orissa, and it's shaping.
So these are all too broad and sweeping, sir.
I understand.
Just you come with specific instances. You say permitting the petitioner to highlight specific instances where directions may be issued.
I am appointed as an amicus curiae in this case.
All right.
May I say, actually the counter file by OP number 2, the government are also OP number 3. What I find.
Petitioner is not there. Petitioner is not. I think.
No, amicus curiae. I am appointed.
No, you are the petitioner is not pressing the petition. Since last 5 years, it is not listed.
No, I have been appointed by amicus curiae.
I read, sir, but still there must be somebody for the petitioner.
Yes, that is it.
Because the petition received by the honorable, and thereafter they have appointed me to assist the court. Amicus.
Fine, sir, but if the petitioner is not willing to press for the petition, then what happens?
Well, that is well disposed of this.
None appears to the petitioner. This was not possible.
Item number 34.
None appears dismissal not possible.
Pardon, my lord. Item number 34 may kindly be taken up after 12 o'clock.
Why? What is special about 12 o'clock?
My lord, Mr. Panda is busy in another matter.
So you either ask for a passover. What is this 12 o'clock?
Passover, my lord.
Passover.
Item number 35.
It has become infructuous. I am for Union of India. The tender was for the period 2016 and 2017.
The petitioner tender infructuous is disposed of as such. All right.
Item number 36. My presence has been noted. Opposition 3. Item number 36.
None appears dismissal not possible.
Item number 37.
None appears dismissal not possible.
I am present, madam.
Item number 38.
37.
And I am appearing for the petitioner. This is the public interest release, my lord. This earlier the petitioner Alexander Senapati, he has expired. I have just filed an application to bring in another public interest person in his name. another change the name, bring a record. This subject matter of this public interest litigation is 11 villagers approached this honorable court. The government notified for taking up consultation operations started. That's annexure 2, my lord. Then that was cancelled in annexure 3, my lord. Consolidation operation was stalled. Then the government in the 4th annexure, my lord, notified to carry on special survey settlement operations. That is not acted upon, my lord.
You can make a fresh representation, sir. Nothing's happened in the last six years. Permitting petitioners to make a fresh representation if any cause of action provides. The petition is disposed.
That's the representation pending in annexure 6.
Make fresh representation, sir. Yes.
Item number 38.
Representation, baby.
It not infructuous.
But infructuous disposed of.
Item number 39.
None appears disposed in opposite.
Item number 40.
None appears disposed in opposite.
Item number 41.
41 no instruction
Disposed of. All right.
Item number 42.
None appears disposed in order.
Item number 43.
I think 42, the petitioner in July, withdrew it. Essentially, same. 43.
Item number 43.
None appears disposed in order.
Item number 44.
May I please, your lords? So this is a PIL. People having with muscle power obstructing the public road and using the public fund for their personal purpose and using the government land for mine flat mining quarry, and after giving the representation to the application to the Tahsildar not taking any step since 2016.
You also have encroached, sir. Come to para 7 of the counter.
So counter is not restricted, short to us.
It's all right. They'll show you a copy. You are also an encroacher. That's what the counter says. Both of you are encroaching. And there's already an encroachment case.
The counter is not received, sir, because of that.
It's all right. You see, it appears that the petitioner, it is seen from the report, counter affidavit of the opposite party that the revenue inspector Begunia conducted an inquiry which showed that apart from opposite party number 5, the petitioner himself has also encroached on government land. There are 2 encroachment cases already initiated. That is encroachment case number 115 of 2016 against the petitioner and 156 of 2017 against opposite party number 5. The court expects both encroachment cases to be carried to the logical end, if not already done. So the petition is disposed of.
Item number 45.
I'm for the opposite party municipality, my lord.
All right. None appears dismissed and not execution.
My lord, the interim orders may be vacated.
Obviously, sir. Yes.
And my name may be noted.
Definitely, sir.
Item number 46.
None appears dismissed and opposition.
Item number 47.
Okay, sir. Permit to withdraw also.
Counsel for the petitioner seeks leave to withdraw the petition. This is withdraw.
Item number 48.
None appears dismissed and opposition.
I'm for the opposite party, 12 and 13.
All right, sir. All right.
Item number 49.
In 9, my lord, pardon, my lord, I'm in VC, my lord. My lord, this is against, my lord, this is PIL against the rejudication of Gochar land, my lord. My lord, by order dated 16/3/2020, the State Council has been directed to take instruction, my lord. And my lord, this honorable court has allowed the petitioner to raise objection, my lord. My lord, pending disposal of the objection, the government has already allotted the land in favor of a sawmill, my lord. And my lord, that sawmill is a necessary party, my lord. My lord, may allow to amend the petition, my lord.
No, you file a fresh petition, sir. In view of the subsequent developments, the petitioner is permitted to withdraw the present petition and file a fresh petition. In accordance with law, dismisses withdrawn liberty is paid out. Yes.
Fresh admission. Item number 50.
Became infructuous.
All right. Infructuous disposed of as such.
Item number 51.
None appears
Item number
dismissal not.
51.
51, my lord, I am in 51, my lord, I am in VC, my lord. Your lordship may kindly see that the settlement operation in the area, my lord, that is Mouja Bindhan of the district Jajpur, has not been held since last 90 years, my lord. And I have already filed representation before
Or the petitioner's representation, bracket annexure 3, will be given by the collector Jajpur, and after notice the petitioner and giving him a hearing. A reasoned order shall be passed not later than 5th December 2022 and be made available to the petitioner within a week thereafter. The court clarifies it is not expressed in the view of the matter. The petition is disposed of.
Item number 52.
Ma'am, item 52, this is a PIL, my lord. My representation, our representations are under annexure 7 series.
You have to go Commissioner of Endowments for all this. Why is the PIL? Why are you coming when the PIL when you have to go to the Commissioner of Endowments?
This is related to the DT of Ma Tarini Ghotaga, Ma Tarini Endowment of Ghotaga, Ma Tarini Temple Trust Ghotaga. The committee, interim committee, which is now continuing, even after their expiry of their tenure, they are
May I
continuing.
submit one thing to my lords?
Yes.
Just in your favor. Your lordship may call it next week along with some other matters in which has been granted, and that is also we have been mentioning before lordship is to that may be called so that all related.
Oh, this is
I am giving the numbers to the postmaster. This is Ghotaga Tarini temple. Na? Ghotaga.
Along with which
I am giving the numbers.
Or
there are 4 to 5.
List on the 8th September.
My lord, next Monday, because that case is also we have been mentioning because the expiry the term has already been expired. They have been forcibly government is trying to
12th. So
12th.
12th. All right.
12th. Okay.
12th on 12th along with we'll give the numbers.
I am giving the list of them.
Item number 53.
Item number 53, let's kindly taken up after lunch. Pass over this matter.
Pass, so we'll just pass it over. Right.
Item number 54.
In this application, I have challenged the order of the Honorable Single Judge. The brief case, the petitioner is working as a Daftari Mailer. In a departmental proceeding, he has been dismissed Mailer. He has adjusted the appeal Mailer. Before the Single Judge, he has taken the ground that the charge is defective because the charge sheet does not contain list of witness and the list of document, my lord. And also preliminary inquiry report was not supplied, that was executed before the inquiry officer, my lord. Third ground, my lord, the inquiry officer not examined taken any oral evidence against the charges, my lord. The inquiry report totally based on documentary evidence, my lord. Only all these 2 points have raised before the learned Single Judge. My lord, the Honorable Single Judge, accepting the views submitted by the bank authority that the punishment is proportionate and court cannot sit as a appellate authority, and also an extraneous matter submission he has made that he has lost the trust. That is not the order of the disciplinary authority nor in the appellate authority, my lord, because it is irregularities, my lord. In paragraph 15, my lord, the Honorable Single Judge has stated that the proven misconduct, my lord. My case that since no oral evidence has been taken against the charges, the charge has not been proved. And also charge sheet never contains the list of document and the list of witness, my lord. On that ground, on denial of reasonable opportunity and as per rule, my lord, no oral evidence has been taken. I have also brought 2 decisions, 82 Supreme Court, my lord, regarding a preliminary inquiry report that has been utilized, not supplied, and also 69 Supreme Court in case of no oral evidence, my lord, against the charges. Only 2 witness were examined. One is bank manager, another is the officer who has given the preliminary inquiry report, my lord. None of the charges, no witness was examined, my lord. That is my case, my lord.
All right.
Well, that has been not, no findings, nothing, my lord.
And the inquiry has been conducted in accordance with the code, that is the Canara Bank Service Code disciplinary action. That your lordship kindly see that the appellant himself confesses the entire committed mistake. So on the basis of the documents as well as the documents and confess, they have disposed of the inquiry officer came to the conclusion that findings are, the guilty has been proved, and accordingly in accordance with the disciplinary code, my lord, he has been punished dismissal of service. The appeal has been rejected also.
What do you say to that case law he's citing?
82 Supreme Court?
No, I'm asking him what he's saying about those judgments.
My lord, 82 Supreme Court regarding charge sheet not furnishing necessary particulars statement of witness recorded during preliminary inquiry, also not furnished. The delinquent was denied opportunity to defend himself at the disciplinary inquiry. Dismissal order is illegal, my lord. The charge sheet never contains. I am supplying, my lord. And regarding 69 Supreme Court, none of the charges, no oral evidence. Lord, simply say the face of the record, inquiry officer itself, he has the findings that he has only dealt the documentary evidence, my lord. And charge sheet not contains number of documents, not contain any of the document. And that document was never supplied. I seen in the during the inquiry, my lord. And he is a daftari, my lord.
You submit a written note, sir. You say orders reserved, both parties
My lord, I will
to file the respective notes of submissions within 1 week. Within 1 week, please give your written note. Yes.
Item number 55.
Well, I will submit written note in court, man. Within a week, man. Within a week, I'll do it.
Item number 55.
May I please? Let's turn to annex to page 86.
What's the delay, sir?
Delay during the COVID period. Disposed upon 26/7/2021, filed on 24/9/2020.
and therefore. Yes.
Let's turn to page 86 annex.
This again the same thing.
Yes.
We adjourn Saturday.
Yes, ma'am.
Where is that order? You have a copy of the order? We're passing so many orders, sir.
Yes, ma'am. I'll pass.
Not helping at all, sir. You have to keep these orders ready.
That is WPC number 35575 of 2020.
You see, this appeal is adjourned sine die, awaiting the judge bench of the Supreme Court in the issue of applicability of the rehabilitation assistance scheme. Date of applicability of the new policy, new rehabilitation assistance scheme. All right. That's it. Liberty granted to mention for listing thereafter.
Next, sir, to be stayed.
No, can't be stayed, sir.
Because there is a contempt petition is filed.
Naturally, that will also have to get adjourned only.
So in that
you have to tell the concerned judge that. Yes.
In that contempt, if some direction has been given to implement that order was
you will have to point out same thing, which is that Supreme Court larger bench is considered. Yes.
Item number 56 for orders.
May please your lordship. This is a PIL matter, my lord. Matter relates to Sishu Bhavan, my lord.
Yes.
This matter appears today's list as per order number 35, dated 19/7/2022.
Correct. What
and the opposite party is supposed to file their reply, my lord. Till day we have not received any reply.
Plus, I'm filing the reply. Plus, we made arrangements and we have taken steps. You also say I filed the documents also along with the Affidavit will also.
Give me a copy, sir.
No copy has been given.
28252 of 2011. All right. A reply has been filed today. Pursuant to the order dated 19 July 2022. Copy thereof we provided to
Well, some time may be given.
which PLs have been adjourned. There must be a list. So, no, not this, sir. PILs. There's a whole list of PILs. October 18th.
May I pray, my lord? Some time may be given so that you can give reply.
18th October.
October. Obliged.
Item number 57.
None appears to be.
Item number 58.
None appears to.
58 is a fresh admission, my lord.
Oh, 58 is passed over.
Item number 59.
Pass over.
Item number 60.
My lord, item number 60, I'm appearing in virtual mode. There's a PIL filed by a villager of Chintolo relating to construction of Anganwadi center on a private land. My annex representation is pending before the CDPO.
All right. The petitioner's representation. What is there to show this representation delivered?
My lord, I have filed the in page number 10, receipt of the postal receipt. Series of letters have been filed. One of the receipt has.
All right. Petitioner's representation dated 13 June 2022 shall be examined by the CDPO, Saratpur Jajpur. Opposite party number 3. Now, after giving the petitioner a hearing, a reasoned order should be passed there or not later than 1st November 2022 and be made available to the party within a week thereafter. The court clarifies it is not expressed in again. The petitioner is disposed of.
Item number 61.
61 pass over.
Item number 62.
62 is a PIL, lords. Lords, the grievance of the petitioners, lords, one of the oldest side this Kotak Municipal Corporation area. Their grievance is that municipality is constructing lords waste dumpers yard lords within the lords residential area.
Anyway,
lords,
what is that to show your representations have been delivered?
Representation lords we have made to the Commissioner Municipal Corporation. It is still to be decided by them.
What is that to show you have actually delivered these representations? Where is the proof of delivery of these representations?
They have, you'll also kindly see page 31. They have received 25/10/2021.
There's no stamp, nothing, sir. There is no stamp.
Lords, they have received.
There should be a stamp of the collector's commissioner's office.
Lords, it is lords, they do not affix any stamp, lords.
No,
they simply receive
that
it.
is not correct, sir. That is not correct.
Lords, you may take up tomorrow, then I will provide receipt.
All right. At the request of counsel, the petitioner list on 12th.
Item number 63.
Tomorrow, lordship deferred. Because they are going on constructing the garbage, lords. Therefore, lords, it is very urgent. Lords may take up tomorrow.
No, sir.
Item number 63.
Pass over.
May I please
63.
This is a public litigation filed by the petitioner seeking direction to the collector, district magistrate Sundargarh, to take appropriate action, immediate action for land acquisition process for construction of the railway overbridge. My lord. The railway overbridge was sanctioned and the matter is the construction has been kept pending for non-availability completion of the land acquisition process. My lord. We have submitted application before the collector under annexure on page 9 and also submitted to other authorities. We have obtained the RTA report from the authority.
Or the petitioner's representatives bracket annexure 1 shall be considered by the
Collector
Sundargarh, and after notice to the petitioner as well as the railways, and after giving a hearing, a reasoned order shall be passed not later than 1st November 2022. Not 1st November, 1st December.
Okay.
The court clarifies it is not expressed in the matter.
Item number 64.
Wait, please, ma'am.
Yes.
The public interest litigation, my lords, by the villagers, my lords, objecting to the query of auction, to the auction of queries 7 and 8 in my lords Dharmasala block, on the ground that it is within my lords 100 and 150 meters village within the in proximity within 100 and 150 meters of the query, my lords. Now this, while we can't as villagers, my lords, I understand we can't object to the right of the my lords,
some representations you made.
My lords, representations have been made. I'll just point out just two things to your lords. I'll not take much time. Page 15, Rule 33, conditions of query lease. The lessee, sub-rule 24, the lessee shall ensure proper maintenance of hill slopes so as to prevent major erosion and observe all safeguards as provided in the Mines Act 1952.
So these will all be disputed persons. Let them consider
Whether they have provided it.
That is the caveat. And also,
who's the lessee?
I have no idea. It does probably.
They have to be heard, sir. You have to make parties. If they are carrying on some mining operations, they'll be affected if any orders pass behind their back.
No, it was supposed to be auctioned. It must have been auctioned on after the writ was filed. Auction has been held. No, it has not, probably not been settled with anybody as yet because it will take time to settle.
Anyway,
now, there are two caveats, my lords. One is that page 35, there is a DGM, my lord, this is our representation. And my lords, annexure 5 is the DGMS circular. This is to all owners, agents, and managers of mines.
Unless specific parties, how are they going to proceed in the matter? Who's the one nobody's been allotted the lease yet?
No. Nobody has been allotted.
Let them consider your representation.
Yes, the collector may be done.
My lords, with specific reference to the Mine Safety Act and the DGMS circular.
If that's your representation, they have to consider it, sir. You say, and they'll be giving you a hearing. That hearing can point out all this. The petitioner's representation, bracket annexure 4, shall be considered by the collector, Jajpur, and after giving the petitioners a hearing.
And any other stakeholders, because if in the meantime the lease.
And other stakeholders a hearing, a reasoned order shall be passed not later than 1st December 2022. The court clarifies it is not expressed.
Until then, there is no blasting if.
No, we can't.
No operation. We are not
open to the petitioners to request the collector to issue interim directions. Yes.
Mallards. Obliged.
Item number 65.
Urgent copy of your lordship.
Yes.
Obliged.
May I please, ma'am? My lord, here what has happened, my lord, under annexure 2, lordship may kindly use page 34.
Again, representations of the petitioner's representations annexure 5.
Representation is at, my lord,
shall be considered by
annexure 5 series.
Collector Jashpur, Mayurbanj, and is it Tahsildar Jashpur?
No, my lord. Tahsildar Josipur.
That is
Josipur. That is within the district in Mayurbanj.
No. So is it enough if he considers it?
My lord, collector maybe.
Collector Mayurbanj.
The collector
hearing the petitioner as well as opposite parties.
Representation is pending, my lord, before the collector at page 116.
What? You're not listening, sir. 5 to 42. And after giving them a hearing, a detailed order shall be passed not later than 5th December. And we communicate to the parties within a week thereafter. Court clarifies it is not expressed in any matter. All right.
Obliged.
Item number 66.
May it please your lordships. Lord, this is a public interest litigation by these petitioners who are villagers objecting to the construction of an Anganwadi center which is adjacent to an open pond, my lord. Lord, this is attached Google Map screenshots and also photographs.
Hey, representations are there.
Representation is there, my lord.
What is that? The proof of submission of these representation. That's not there, sir.
Yes, but that's not there.
So then we'll have to make a fresh representation. So permitting the petitioners to make a fresh representation to the authorities, and after following up on such representation to seek appropriate remedies in accordance with law.
Right.
Petition is disposed of. Right.
Obliged.
Item number 67 for orders.
67.
May I please?
Delay is what? COVID delay.
Limitation during COVID period.
And then what?
That will also turn to phase 19 in the order.
First day.
First day, and also directed to regularize, but our scheme is otherwise. I've annexed that scheme.
Or to say notice additionally be served on counsel appearing for the respondent before the single judge. Till the next date of hearing, there shall be a stay of the impugned order. List on 6th December. Next one, same.
67, 68, 69, 77.
Same, all. Same.
Item number 71.
This is also within that COVID period. My limit is
delay is condoned. What's the issue, sir?
Well, that promotion direction has been given to give him promotion during pendency of the criminal case.
Oh, okay. Notice.
The lordship has fixed it to 28/10/2022.
All right. Notice returnable 28/10. There should be a stay of the impugned order. All right.
Item number 72.
May I please? The case of the appellant is that, my lord, though the appellant case is different, but in common judgment, the honorable single judge has passed, my lord. My case, my prayer, my lord, kindly say page 18 of the writ. Perhaps watch that before the honorable single bench, my lord.
There's some defect. We removed it.
My lord.
List after defects we removed within a week, list thereafter. All right.
Item number 73.
1839 of 22.
May I please, Your Honor?
The office has pointed out there is no delay. This application is disposed of.
Well, item 73, my lord. Well, item 73, my lord. Today I am filing a IA application for my leave to appeal, my lord. My lord, dated 25/11/2020, passed by the learned single judge, my lord, where I was not made a party, my lord. The case is
a notice till the next date of hearing. There shall be a stay of the impugned order.
Deeply obliged, my lord.
Notice returnable 28th November.
Item number 74.
Yeah, in 74, my lord, after deduction of that limitation period, 67 days delay.
The delay is condoned. And what's the matter about?
That matter relating to the rehabilitation of 2020 rule.
You see, John Sinada awaiting the judgment of the Supreme Court. Right.
Item number 75.
Delay is condoned.
75, my lord, may I frame this matter, lordship may call this matter along with WA number 687 of 2020-22.
When is that listed?
That is the main matter that the order has been passed in that case.
When is it listed?
Not listed till.
This is 903, that 687 is not listed.
No, my lord. 687 of 2020.
Okay, list this along with 687 of 2022.
My lord.
On 19th September. All right.
Item number 76.
Here also there is a delay of 67 days.
Delays condoned, yes.
At that first day disposal to regularization at page, order is at page 36.
All right. You are there?
No,
Notice. When are these matters coming up?
My lord.
When is similar matter coming up?
On 31st November, regulation to 1 DLR. 28th November.
28th November till the next day there shall be a stay of the
Item number 77 for orders, criminal appeal.
May I please, Your Lordship? The instruction was sought for regarding interim bail, Your Lordship.
This instruction has been received on 23rd August. Sending for lawsuit scan perusal.
What are the
It has been ascertained that Srimati Barsu Himerika, applicant's mother, was suffering from gynec problem earlier and was undergoing treatment at DHS Rayagada. MO DHS Rayagada referred her to MKCG Medical College Berhampur for treatment, but she denied to go to Berhampur.
The fact, Your Lordship, there is no male person in the family, Your Lordship. He is unable to move to the medical, Your Lordship. There is no other member, Your Lordship. The present petitioner being the since
what is the ailment?
Gynec problem. Only it has been written gynec problem.
No, is there any other male member or a female member? Anybody to take her?
No, unless the
I'm asking him, please.
The page 5 of the page 5 of the IA Lordship, I have annexed the letter of the Sarpanch Lordship. This is in Oriya, but it is the Sarpanch clearly describe the situation of the family law. My
reject is the 14 On 14th August, the interim prayer was rejected.
No, this is 21. 14th August 21. 1 year back.
1 year back.
18/8/21. This is on 18/8/21. There was interim prayer by the appellant LLC, which was refused by this honorable court. It's 1 year back. Since then, he's lying in the house LLC. There is no the treatment. Nothing is there.
No, you were referred to the Berhampur hospital, but you denied to go there for treatment. Your wife.
The denial due to no male member is there to look after her, and there is no financial support to move to the hospital LLC. My lords, Justice Das can be this is the Oriya. I have annexer page 5 will also annexer a series lordship. The Sarpanch of the local GPO lordship has expressed the condition of the family lordship.
No, but her health condition now is fine. That's what it says.
No, my lordship.
Just show that. The last line of that report.
That is the condition is so precarious since last 1 year. Lordship.
No. Just see the report. Last line of the report. You can always apply a pressure. The report reveals that at present, the petitioner's wife is not suffering from any ailment. As and when any such emergency develops, it will be open to the applicant, appellant, to file an appropriate application in accordance with law. The application is disposed of. Are paper books ready in the main matter?
No, my lords.
You say paper books be readied and supplied to the parties within 8 weeks, including the list of final hearing matters thereafter.
Item number 78.
Oblige.
That stay of fine, I think you can allow. 1031. Here also that stay of fine that you can allow. 1010. Yes, sir.
My lord, this is split up case and the other co-appellant appeal disposed of by this honorable court.
And the petition. Supply the deposition copies. I don't have the deposition. Sorry, I don't have the deposition copies.
Your lordship, the only ground of consideration that period of
copies of the deposition, sir. Counsel for the appellant states that he will hand over.
My
to
lord, he is
counsel
in
for the state.
custody from 2008, my lord.
You have to give him copies of deposition. Let him get instruction.
My lord.
Copies of
My lord,
deposition
fix
be
a
handed over to counsel for the state before the next within 1 week. List on 27 September. Fine realization state.
Item number 79.
79, may I please, my lords. My lord, let's kindly see the IA number
Yes, I
one,
have obtained the instructions.
flag C.
I have obtained the instructions. I have filed it on Saturday and it's a hard copy.
He died on 29th, his mother died.
It's correct.
The report of the IAC confirms that the petitioner's mother expired on 29th August 2022. That be the matter. The applicant appellant is directed to be enlarged on interim bail, released on interim bail for a period of 2 weeks.
I prayed for 1 month. I lost of pages. Throughout his trial court, he has bail and never misutilized his liberty, my lord. Since 9/1/2018.
There must be a purpose, sir. Everything has a purpose.
Yes,
You can't just go away for 1 month. The death has already taken place. For 2 weeks, we are granting you.
That's Raju Lordship pages.
For a period of 2 weeks from the date of his release. Subject to terms that may be imposed by the trial court.
The urgent certified copy. My lord, I have a
Yeah,
small
urgent
prayer.
certified copy be issued to the parties. The surrender certificate should be placed on record immediately after the expiry of the interim bail period.
The course of this urgent certified copy, my lord.
Yes, I've already said that.
But I have a small prayer. If Lordship permit,
In the main appeal, you say paper books be prepared and supplied to the parties within 8 weeks, including the list of final hearing matters thereafter. Yes.
In this case, I am for the informant. The previous case, 79.
All right.
There are connected appeals, my lord. There.
Maybe may not be, but my case is separate.
There are 5 connected appeals arising out of same case.
Oh, I see. But let them come up, then you point out.
Item number 80.
80, my lord, I pray, my lord, 13th or 15th it may come, my lord.
Sorry?
It may come, my lord, 13th or 15th, my lord. I am going file a IA for bail and still some file. I pray, my lord, 13th or 15th.
Anyway, paper books be prepared within 8 weeks and supplied to the parties. List, including the list of final hearing matters thereafter. When we file the little counts. Yes.
Item number 81.
Fine realization state 1119 of 2022. IA.
My lord, may I please? The petitioner was on bail, my lord, during the trial, my lord. Convicted under section 302, my lord.
How long has he been in?
My lord?
How long has he been in jail?
My lord, during trial, my lord, 1 year, and after the judgment, my lord, 3 months.
Then this is hardly the time. Not inclined at this stage. You say
your lordship may lie over my I for bail, man. Your lordship may kindly lie over the.
Say this fine realization state. Paper books be prepared within 8 weeks, including the list of final hearing matters thereafter. Right.
Item number 82.
Fine realization state.
I'm for the appellate lordship, kindly 1 week time granted. I'm not fully prepared, so I will prepare.
Sorry?
In this matter, I'm for the appellant, and kindly 1 week time may be granted for I'm not prepared.
No, we'll anyway admit the fine realization state. Paper books be prepared within 8 weeks and supplied to counsel of the parties, including the list of final hearing matters. Right.
Item number 83 for admission.
Nana.
In this case, the villagers under the PAL for construction of an underpass within the railway track leading from the Tikri railway station to the plant of the opposite part number 3. The railway track has been laid in the middle portion of the village.
So 2013 matter, sir. It's a very old matter. 9 years old.
The railway council had taken instruction to file counter affidavit.
It's a 2013 matter. Where's the question of counter and all that?
Since
if any cause of action survives, you make a fresh representation. That's the only thing you can say. If any cause of action it will be open to the petitioners to make a fresh representation, and after following up on such representation, to seek appropriate remedies in accordance with law. The petition is disposed of in the above terms. Yes.
Item number 84.
Lordship, item number 84, my lord, that's a connected writ petition 9929 of 2020. Lordship, this is covered by Lordship judgment against fees. The opposite parties in appeal before the Supreme Court. The SLP is pending as they stated last time. Lordship, all these matters were adjourned to 7th September.
All right, list on 7th. That's day after.
Stay to continue, my lord, in both the
Within 2 days, sir, nothing is going to happen.
No.
Today is 5th, the day after the 7th. All right.
No, in that matter already, the stay order was passed by the Honorable Single Judge. And
Anyway, sir, we are only calling out 7th. Yes.
then the order has been modified.
All right, sir. All right.
No stay order, nothing.
Item number 85.
My lord, 84, there are two other applications. 11885, my lord, and the first item is 7090-2016, my lord. These are concerning to the user's charges. So the petitioner, in fact, my lord, has a last prayer to my lord, so having an exhaust to file the rejoinder. They have not filed the rejoinder today.
Anyway, we're calling it all on 7th. Yeah.
7th, my lord, because that item, these items are separate. These are the user charges, and the item that was mentioned earlier, that is holding.
My lord, that is interconnected, my lord, because, my lord, we are challenging that you cannot charge
All
both.
right, sir, we're calling on 7th.
My lord,
Yes.
that is what, my lord.
Call out the next matter.
Item number 85.
Let's show item 85.
Item 85, my lord, I am appearing for the opposite party, number 1, my lord. Your lordship, my lord, friend may be permitted to correct the cost title of the OP number 1, because now the PI is functioning under the Berhampur, my lord. I have received the instruction that regarding grievance for the petition has been taken care of, and about 95% work has been already completed. I have received the instruction today, my lord. If you all permit me, I file a short affidavit.
All right. Counsel for the NHAI states that he'll file a short affidavit.
But the OP
Within
number
2
1 will be
weeks.
corrected.
Just on 28th September.
Let's
Item number 86.
Let me turn to page 21, annexure 1.
Delays COVID, is it?
The lordship already issued notice. No one has appeared.
No. Come back unserved, sir.
This is the
Receive back. Unserved. No, neither unserved notice nor AD receive back from the sole respondent. Fresh notice in the main writ appeal by registered speed post. Returnable on 22nd November. The tracking report will be placed in record.
Item number 87.
Item number 87, my lord. Kindly give it a passover as the.
All right.
Yes.
Item number 88.
So, item number 88, in this case, my lord, prayer number 4 and 8 has already become impetuous. For other surviving prayers, the lordship have directed both Union of India and also Income Tax Department to file counter separately. In the meantime, department has filed counter. Mr. Pari, I think, has to take call to file counter for Union of India. It has not been filed.
Right.
I lost my pardon.
Replies be filed within 8 weeks, rejoined up for the next date.
Because this assessment for 21-22, if assessment were there, we'll all this 34.
12th December.
So,
all right.
Minus.
Oh,
Publishment.
Item number
18. I will respond to them after that.
Item number 89.
All right. I'm appearing for OP number 8. I'm filing the counter in course of the day. It is already ready. I'm filing it just now. Just
So far as our counter is concerned, I have received the PwC. I will take 1 week.
All right.
I am appearing for the OP number 6, my lord.
States that he'll be filing his reply within 2 weeks. Within the same period, the other opposite parties may also file the replies. Rejoined for the next date.
I'm filing today.
List on 29th November.
Grateful.
Item number 90.
Item 90, if I may please your lordship, I'm for the petitioner, my lord, and we are withdrawing this application.
All right.
Lead
Counsel,
application.
the petitioner seeks leave to withdraw this application. Dismissed as withdrawn.
Item number 91 for hearing.
Passover items are there.
Lordships may mark the attendance.
All right. All right.
My lord, After 90 passover items are there, before your lordship goes to hearing matters, there are 3 passover items.
Passover matter, item number 30.
May I please, my lord?
So many defects anyway. Yes. Not even come up once. This is remarkable. 8 years. Never listed even once.
Yeah, this is also listed.
Dozer, post of dozer dumper operator. Same thing as the earlier one.
Yes, my lord, dumper operators.
But here not even notice has gone.
No, my lord.
And there no stay of the impugned order anyway.
My lord, my only limited.
Same, no requisite, same. Everything is same. It's an identical order as an earlier matter.
Yes, my lord.
But how come not even once
It could not
in the last 8 years?
My lord, I have only limited that prayer since post are vacant, my lord. Since that's why this writ application.
You don't know in the last 8 years whether posts are vacant or not. How do you know? Unless the person from MCL appears. Where is Mr. Monty? Mr. Devraj Monty?
My lord,
Mr. Monty. Mr. Devraj Monty. There are so many ML matters, sir. You are not present at all.
I'm sorry, man.
Which was your earlier matter? That other dozer dumper and all that?
Let me sort the copy, my lord.
You give him a copy. A copy of the paper we supplied to Mr. Devraj Monty, counsel to the MCL. Call on for him to take instructions on whether there are any vacant posts.
Yes, my lord.
Available against which the appellant can be accommodated.
Yes, ma'am.
List on 21st November. All right.
Obliged, 21st.
Passover item number 34.
May I please your lordship, ma'am? The consolidation matter, consolidation of operation on basis of the notification filed by the state, where the notice on section 18 publication has been made for objection. The petition has filed objection by the annexure 11 without.
Then there's no PIL here, sir. Under the consolidation law, there must be a procedure.
Objections are there if that is not considered or not favorably considered, that can be challenged in revision. And moreover, what is the current status there? Because it is 6 years past in the meanwhile. Final publication must have been made.
You find out, sir.
Final publication.
Mr. D.K. Manthi, learned AGA states that he'll find out the current position of the consolidation operations.
Of the concerned village.
Of the concerned village. List on 30th November.
Passover matter item number 53.
53.
May I please, my lord?
Yes.
My lord, in this case, my lord, can I state certain background, my lord? What happened? The petitioner joined at Puri as a ward boy in the 1989, my lord. Thereafter, he got transferred to Jaipur, Rajasthan, my lord.
Maybe there are no cause of action surviving.
Yes, my lord, only the pensionary benefits. My whole limited prayer, my lord. Kindly have a glance to page 10, my lord. Page 10.
All these matters have not even come once. It is so strange. The last 3 years, it is not even listed once.
State Council, Center Council Research in Homeopathy.
Copy nahi. Copy dega.
Very long order.
Kete number na?
Yes.
My lord, only that period, that unauthorized absence. My lord, my only submission that may be no work for no pay. But the above period will not count for pensionary benefits, my lord. My lord, this needs opportunity of hearing, inquiry, my lord. Because this is pensionary benefit will not be counted, my lord. And my lord, while at all along, my lord, writ petition I have filed And in the first writ petition, it was directed to dispose of my representation. And after considering my representation, they have rejected. Thereafter, again, I filed another writ petition. While there was a direction, the petitioner will not be transferred to Rajasthan because since he is a low-paid employee, my lord. And my lord, to consider the case of the petitioner sympathetically. And my lord, my only prayer is not to consider that period from 2012-95 to 16-5-255 only for the purpose of pensionary benefit, my lord. Because otherwise, he is a mega salary employee, my lord. My lord, if you won't be getting availing benefit of pensionary benefits.
Unauthorized absence. I don't think we should interfere in this. These are not matters for interference, madam. We'll pass the order. Writ appeal is dismissed. Yes. Writ appeal dismissed. The detailed order will be passed later.
Passover matter, item number 58.
Despite a Passover, none appears. This was not prosecution.
Before your lordship takes up the new list, may I make a small suggestion?
1 minute, sir. We are, I think, midst of Passover. Let's.
I'm sorry.
Passover 58. Item number.
50. With that, it's over.
No, 59, Passover 59.
61.
58 have finished, sir. Dismissed for non-prosecution. Which is the next
59.
Passover.
59. Sir.
You have to be loud, sir. Otherwise, the lawyers will start arguing. Call out clearly.
Item number 59.
Yes.
Yes. 61, copy 9. Copy 9.
None appears despite a Passover. This was a non-prosecution.
Passover matter, item number 61.
My lord, may I please, your lordship?
Yes.
Say PIL, my lord.
Yes.
Here the petitioners are the members of the association of Raja Bagija Labour Colony, my lord. This is original. This labor colony was a government quarters allotted to the different employees under the state government, my lord. Subsequently, the respective quarters were settled with the employees, my lord. Now the OP number 5, my lord, being a lottery winner, he has started functioning a OPSUF inside the residential crowded area, my lord. Because the OP number 6 is a one.
Suddenly happened, sir. There must have been a notice. You must have filed an objection.
We have filed our objection, my lordship. Annex 3 series. Since date of functioning, we have continuously made grievance before the collector and the superintendent.
Mr. D.K. Mohanty states that he needs time for instructions. At his request list on 9th November.
Copy 9.
Passover matter, item number 87.
May it please your lordship. Lordship, it's a writ appeal, my lord, against the order at annexure page 14, my lord, annexure 1, order dated 23/11/2021. My lord, a limited grievance against this order is, my lord, may kindly see at page 15 of your lordship's brief. The Council of Paradip Port Trust brought to the notice of the Honorable Single Judge that this matter is actually pending before the Apex Court. And, my lord, despite that, my lord, we have been directed to consider the case. My lord, we have our hands tied. My lord, may kindly see the writ appeal, wherein we have stated the details. My lord, the present petitioner was taken as an contractual employee in 2008, my lord. In 2011, a batch of matters.
To place and record the recruitment rules governing the.
My lord, that was because, my lord, in the previous bench that it was, my lord, Justice Singh wanted to see those orders, my lord. But that was before any hearing took place. He just wanted those on record, my lord.
Have you placed them on record?
Yes, my lord. We have, my lord. We have filed an additional affidavit, my lord.
All right. You just say the pursuant to the orders passed on 11th May and 22nd June 2022, the rules and relevant orders have been placed on record. It's a notice returnable. So Shashir Purohit is there. The name of Mr. Shishir Purohit is
Yes,
shown.
my lord, because he was appearing in, I believe he was appearing before the writ petition, my lord. That's why the name.
Oh, notice returnable.
That's usually how the system. That's
Oh,
how.
notice returnable 30th November. The interim order to continue.
Grateful, my lord.
Yes, Mr. Das, now you can tell us.
Minutes. I had taken time before from your lordships on item 4. The whole difficulty is twice I have filed a memo. Office said there is court order, we can't give you any copy. Can I pray for a direction to any competent authority? I have twice filed memo and said that also they said no, unless a court order, we can't give you copy. Memos must be on record in the court below, on the office.
In which item, sir?
That's item 4. I had prayed twice before lordship. My brief has been somewhere misplaced for some reason. I have prepared a small note also I have given to your lordship on the basis of only paper available with me. But I want the criminal appeal, the paper book is necessary.
But today, why don't you send someone with the pen drive right now? We'll give it from the court itself.
I had sent, I'll send it. I'll ask my associate to go there.
During lunch hour, you'll get it.
Obliged. I'll send somebody during lunch hour. Maybe taken up tomorrow or day after tomorrow. Today, bereavement there in my family. The day after tomorrow, I will do it completely.
All right. When we are at the end of that other list, no?
So, do you
There's one final hearing, the end of that other list.
Do you apologize?
92 or 91? Call it 91.
Item 91 for hearing.
Do you apologize? Inadvertently, I have committed a mistake that in item 77, I have shown you lots of a document which is 14/8/2021 on an impression that is 22 plus. That's the reason why your lordship has rejected the interim prayer.
So you call him again. We'll take it up at 2 o'clock. What is the report?
That has not come. So I humbly pray, let it come some other time.
So you better tell him then. Yes. In item 77, at the request of Mr. Katke, I take off the earlier order. Who needs some more time for a report? List on. Call it on Friday?
Man.
Call it on Friday. 16th, you better let him know. Or we'll call it on Thursday, 15th. Not 15th, 8th, sorry. 8th September. You better let him know.
So, my lord, item 45, I was engaged in another court.
Tell us, what is it?
My lord, this is a matter regarding a PAL for the construction of a market complex in front of SDGM quarters. So,
you made a representation?
My lord.
But this is a 2017 matter, sir.
17 matter, my lord. My lord, you have received the counter on behalf of opposite party number 2.
When?
18,
long ago.
18, my lord. This has come up first time, my lord.
Not first time, sir. This is not coming up for the first time. Are you in the same matter or you're simply saying which is your writ petition number?
My lord, 26563 of 2006.
How are you saying for the first time? It was listed on 5th February 2018.
After that, my lord, it has.
After that. Then 11th April 2018 again.
My lord.
16th April it was listed. 30th April it was listed. 7th December 21.
After 18, it has come up in 22.
What about this report from the District Judge Devgarh? We have a report of the District Judge Devgarh. Just see item 45. It called for a report from the District Judge Devgarh. Report not received. A reminder be sent to the District Judge Devgarh to send a report in terms of the order dated 7th December 2021 forthwith. Copy of the said order as well as today's order will be communicated by the registrar administration to the district judge forthwith today at the earliest for compliance. List on 19th October. 41.
Item number 91 for hearing.
For an adjournment, my lord. May I pray for an adjournment, ma'am?
Why do you want an adjournment?
My lord,
Why do you want an adjournment?
today I could not prepare myself.
No. This is not an excuse, please.
Then it may kindly be any day, tomorrow or day after tomorrow. But today it may kindly be adjourned. Tomorrow your lordship may fix it.
Counsel for the appellant wants an adjournment. In the interest of justice, is a last opportunity.
One more prayer, my lord. One IA is there. So your lordship may kindly list it for the orders matter so that I can move the IA, my lord. IA for bail is pending.
So you argue the appeal, madam.
Okay. On the next day I will argue.
12th October.
It's 12th October. Obliged.
Item number 92 for hearing.
In respect of the protected monument now, by lordship's interference, the developmental work is going on. So, the archaeological superintendent archaeologist, OP number 3, my lord, he has sent a proposal to the Director General. So, under the National Conservation Policy, so it approving authority, the Director General. So, soon after the proposal is received, so they will start my lord, the
Who are you for, sir? You're for the petitioner.
I am for the petitioner.
So then you're not. In view of these developments, no need to keep this pending then.
My lord.
In view of the developments, there's no need to keep this PIL pending then.
So, my lord, the OP number annexer 4, our representation has been mitigated by the superintendent archaeologist. So, he has sent a proposal to the Director General.
All right.
So, lordship,
all right. You say in view of the recommendation already sent by the OP number 3,
my lord, superintending archaeologist.
To the Director General ASI.
My lord, OP number 2.
For taking necessary action, no further directions are called for. In the present petition, it is disposed of as such.
My lord.
Item number 93.
My lord, time period soon after receipt.
They said recommendation be acted upon within 8 weeks from
my lord.
Demarcation already been made and that construction to my appearance may be looked at by that time.
Item number 93.
May I please, Lord, sir? My lord, in this case, FIR was registered under section 302, 307 and 294 on dated, my lord, 30 April 2015.
Yes.
Malayalam and Trial Court convicted the appellant under section 302 and the 324 IPC, my lord. In this case, my lord, PW 1 to 6 are the eyewitness and others, PW 7 is the informant and PW 8, 9 is a witness to seizure and 10 is the witness to a postmortem PM report, my lord. In this case, my lord, the fact of the case is that on this head that the apple and the disease was spreading green ground in his field. Due to the previous enmity, the appellant rocked and suddenly attacked by means of a sharpened sword, my lord, aiming to the head. At the time of the occurrence, the deceased was injured in the head, neck, hand, and the abdomen and internal part of the injury also. The postmortem report clearly stated the cause of death of the deceased is the homicide by the hand-sharp cutting weapon. Well, at that stage of the trial, the deposition of the 1 to 6 are omnibus. There, the statement is all equal, and 1 to 6 are the 20 cubic feet from the field of the occurrence. And though out of 6, 1 was male and other 5 was female person, hearing the sound, the informant come to rescue her husband. When she tried to rescue her husband, the appellant also aiming to his head and assaulted. She also fell down. Thereafter, when the other person come to the spot and take to for treatment by help of the 108 ambulance, on the way, doctor declared that is dead. Thereafter, my lord, the FIR was scribed in the in the police station. Then trial is commenced and judgment was passed, my lord, 22 February 2016. and appellant is convicted under section 302 and 324 IPC, my lord. In this case, it cannot be avoidable that the death of the deceased is not by the appellant. It is clearly stated by the Land and Court Order in para number 14, and also the deposition of the IO, my lord. And all the things are seizure, the sharp wooden also seizure by the IO, they are all examined by the IO, my lord. And medical, the informant who was injured was examined as the PW10, the medical officer. He also stated that the informant also seriously injured after come from the hospital, she lost the affair. Only difference that the affair was not scribed by the informant, somebody was scribed. This was taken in the defense in the cross-examination, my lord.
All right. This is all? That is all, sir?
This is all. Or you want to argue further?
No.
All right.
Straight
Orders
case,
reserved, sir.
straight case.
All right. Orders reserved.
Item number 94.
Lesson 94. I received the paper book, but I cannot prepare myself for detailed preparation. So I want for 1 week time.
All right. At the request of counsel for the appellant who needs more time for addressing arguments. 13th October. Mr. Dalai, you're in which matter?
Item number 1. By
Ah, yes. Please come.
Weekly list item number 1 for hearing.
This matter may kindly passed over. Mrs. Patnaik was arguing this matter. No,
sorry?
Mrs. Patnaik was arguing this matter. May kindly passed over.
It has not been argued even. I have not opened the case. The last occasion I had taken time because...
And she is ready in this case.
Yes.
She is appearing
that
before the
must
MD.
be, she is ready, but it has not been started. The argument has not been started.
She is appearing before the Honorable National Green Tribunal. She will be back within 2 minutes. After recess, must.
He will not come. He won't complete before. She can come and join, sir.
She can join. Let here, may it please, Lord. Well, initially, by 6 persons were placed on a trial.
Yes.
In the Court of Additional Sessions, Jaipur.
Right.
Being charged under Section 302 by 34 of the Indian Penal Code and Section 324, read with 120B of the Indian Penal Code. Lord, in trial court was, on an appreciation of evidence on record, was pleased to acquit 2 accused persons, namely Yadu Manmat Rao and Yadu Kumar Swami. Those were accused number 5 and 6 before the trial court. In between, as my information goes, one accused, Alam Umashankar Rao, is no more, he has died. I had 2 appeals, that is criminal appeal number 123 of 96. There the appellants are B. Srinu alias Bobil Srinu and B. Govinda alias B. Govinda Rao. In criminal appeal number 137 of 90, Medi Srinu alias M. Srinivas Rao. Alam Umashankar Rao is no more. His appeal is abated. Appeal with regards to Alam Umashankar Rao is abated.
Right.
As per the prosecution case pilot, there was a dispute between the family of the deceased and the family of the accused Govinda since last 2 to 3 days before the occurrence pilot. Due to such feelings, accused Govinda, his brother Tirnath and his friends, they were threatening the deceased to do away with his life. The name of the deceased is Basa alias Bhaskar Rao. Let me kindly take note of Basa alias Bhaskar Rao is the deceased. So it is alleged that the accused persons and their friends, they were threatening the deceased to do away with his life. On 10/2/93, at around 9 p.m., the informant PW1 with the brother of the deceased and one Kanchan Srinu, examined as PW2, they were standing at Yadu Shahi and were discussing something. At that time, it is alleged, accused M. Srinu being armed with a knife, accused Umashankar armed with a plowshare, accused A. Srinu armed with a spring knife, and accused Govinda armed with an iron chain appeared before them and picked up a quarrel. It is further alleged that while accused M. Srinu stabbed on the abdomen and chest of the deceased, accused B. Srinu stabbed on the chest of the deceased, and accused Govinda, holding the iron chain, gave fist blows on the face of the deceased, and accused Umashankar attempted to assault the deceased by means of that plowshare which was with him. Due to the above assault, the deceased fell down on the ground, and thereafter, one K. Srinu, who has not been examined, and T. Suresh, examined as PW11, took the deceased to the hospital, but the deceased succumbed to the injuries on the way. My lord, the investigating officer, as alleged, PW13, on receiving the information from PW1, got it translated by PW3 because it was in Telugu language, my lord, by PW3 into Oriya, and same was reduced into writing under Exhibit 1. Exhibit 1 is the affair. And the case was registered. After completion of the investigation, charge sheet was submitted and case was committed in due course for trial. And to substantiate the allegation, prosecution has examined around 13 witnesses. Out of the witnesses examined, my lord, PW1 is Purnachandra Rao, is the informant in the case and received injuries on the spot. So he can be taken to be a witness to the occurrence. Kanchan Srinivas Rao is a witness to the occurrence. PW3 ballot is Gangadhar Patra, is a witness who had accompanied PW1 to the police station for lodging the information and translated the report from Telugu to Oriya. And is also a witness to the seizure. PW4 is a witness to the occurrence and who has seen the part of the occurrence. PW5, ballot Dr. Durga Prasad Tripathi is the doctor who had examined PW1. PW6, Gauri Prasad Rao is another brother of the deceased. PW7, my lord, is the doctor who conducted autopsy. PW8 is the constable who is a witness to the seizure of blood stain earth and sample earth under exhibits 7, 8, 9, 10, and 11, respectively. PW9 is a witness to exhibit 8, 9, 10, 11 also, like PW8. PW12 is the father of the deceased. By the way, kindly take note of, I will harp on that. PW12 is the father of the deceased, and PW11 is another friend of the deceased who took the deceased to the hospital. PW13 is the investigating officer of the case who has investigated into the case and submitted charge sheet. Defense in support of the case has examined 4 witnesses. I'll go to that later on, madam.
Yes.
5 witnesses, madam. Facts of the case is, that is admitted fact, there was some sort of dispute between the deceased and the accused persons prior to the occurrence. And admitted case of the prosecution case also, and the investigating officer has also brought out the same, that the deceased was in love with a girl and the family of they were not interested for that, for which that may be an occurrence by the family of that girl, because the dead body was found just in front of that girl's house. First submission, before going in detail, I just want to draw my lord's attention. My first submission, my lord, let me see the affair. Affair is at page 39.
Yes.
They say, my lord, let me see affair exhibit 1 by 1 the signature of the informant at page 40. After this Orissa part, pilot can see the in this part,
Yes.
the signature.
Yes.
It has been corrected from 11 to 10 without any initial. By drawing my lord's attention to this fact, I want to say this has been manipulated. If this could be manipulated, my lord, they want to prepone the case because the occurrence has taken place on 10th, but affair was lost on 11th. There was sufficient time for the prosecution party for exaggeration, embellishment, incorporation, everything. And this has been, my lord, I'm just drawing my lord attention to this, and this has been put to PW3, my lord, who has scribed it, who has turned to Orissa. I'll draw my lord's attention to that. Another fact, my lord, which goes deep into this, my lord may, at this juncture, I want to draw my lord's kind attention to the evidence of PW3. Well, at page 106. At paragraph 11, I will not take my lord's valuable time. I'll draw my lord that prosecution has not come with a clean hand, not proved the case beyond all reasonable doubt, my lord. My lord may see paragraph 11, fourth line, my lord. I have not given date under my signature appearing in the affair. Got it, my lord? Fourth line?
Yes.
I have not given date under my signature appearing in the affair. I saw PW1 cite the affair. PW1, my lord, is the informant. I do not remember if PW1 gave any date below his signature. It is not a fact that on 10/2/93 Exhibit 1 was not prepared at the PS, and on 11/2/93 Exhibit 1 was written and signed by both PW1 and myself. It is not a fact that below the signature of PW1 appearing on Exhibit 1, the date 11 was written and it was subsequently corrected to 10 by the process of overwriting. On a plain white paper affair, this is very, very important, my lord. My lord, this lodging of information in a criminal case where persons are going to be implicated in a case of 302 is not an empty formality, my lord. My lord, he says on a plain white paper, the affair was scribed by the OIC, while PW1 described about the occurrence before him on 10th night. The affair was not drafted on any other paper at first. On both sides of the plain paper, the contents of the affair extended. My lord, may see this affair. This is not a plain paper affair, my lord. The affair which, my lord, I had drawn my lord's attention, again, my lord, may see page 39. This is a format. If something was written in plain paper, where both sides were blank, how could it be, my lord, it appear in the sheet, affair sheet of the written paper? My lord, paragraph 12, PW3 has also stated the IO did, third line, the IO did not reduce the statement of the accused persons to writing while they made these statements. It is not a fact that the drains lying on the roadsides, I think it's not that important. I'm just taking my lord to the time of occurrence. Time of, my lord, here PW1 has said in his evidence, there is power cut from 7:30 to 8:30 p.m. on the date of occurrence, and PW11 in his cross-examination has also stated, I do not remember if the electric light was burning. The availability of light was seriously challenged by the appellants, and it was suggested that the occurrence took place in the dark. In order to overcome such challenge, prosecution ought to have laid evidence, but they have not laid evidence in that respect, and they remain silent, my lord. My lord, with regards to the seizure, this so-called weapon of offense, my lord.
Yes.
It will be seen, my lord, the evidence of PW13, the investigating officer. I just draw my lord's attention 13 at page 145. The BW 13 says,
yes,
at paragraph 2, let me see.
yes. I examined the informant.
My lord?
I examined the informant. Para 2.
My lord, I examined the informant and sent him for medical examination, and he had sustained injuries on his person. I proceeded to the hospital and issued the command certificate directing so and so to guard the dead body and so and so. My lord, exhibit that. Leave these 5 lines. Exhibit 13 is the dead body challenge, so and so. I arrested accused N. Govinda, N. Srinu, and A. Umasankar Rao and examined them. At 3:30 p.m., accused B. Srinu, being under arrest, led me and witness to the drain lying on the eastern side of the police station and gave recovery of a knife from the drain, and I seized the same. My lord, as we are taught, my lord, in law schools and as the law has developed, my lord, section 27 contains 2 parts. One part is the statement before the police. Second part is leading to discovery. Here, my lord, that statement which was before the police that has not been given, my lord, given by prosecution, or that has not been placed on record. In the absence of that statement, so-called leading to discovery, because the seizure list is not available in the record. My lord, we see the relevant seizure list is not found in the record. That is the statement of PW 13. That to what extent it is admissible, and when again I will come to that stage, my lord. The so-called MOs seized under seizure lists, exhibit 7, 8, 9, 10, 11, that was sent to the investigating, I mean to say, a forensic laboratory, my lord. And my lord will see, investigating officer says, very candidly he has admitted, my lord, in the paragraph 4, my lord, we see. Before paragraph 4, we see also paragraph 3. On 12/2/93 at 9 a.m., I seized the wearing apparels of accused B. Govinda Rao, such as a blood-stained yellow colored sweater, a blood-stained banyan, a blood-stained black colored full pant, under the seizure list exhibit 9. At 9:30 a.m., I seized the wearing apparels of accused K. Srinu, such as a blood-stained full pant and a blood-stained full shirt, under the seizure list exhibit 10. At 10 a.m., I seized the wearing apparels of accused B. Srinu, such as a blood-stained full pant and blood-stained check shirt, under the seizure list exhibit 11. At 10:30 a.m., I seized the wearing apparels of accused Umasankar Rao, such as a full pant and a half shirt, both contain stains of blood, under the seizure list exhibit 8. On my prayer, nail clippings of accused B. Srinu, M. Srinu, Umasankar Rao, and B. Govinda Rao were collected by the doctor of Rayagada Hospital. On 12/2/93 at 1 p.m., I forwarded the above 4 accused persons to the court. I received the postmortem examination report and injury report from the doctor. On 26/2/93, I arrested accused Y. Manmadha Rao and forwarded him to the court. On 11/3/93, I arrested accused Y. Kumar Swami and forwarded him to the court. On 29/3/93, I sent the seized knife MO1 to the doctor to ascertain from him if that injury found on the deceased at the time of postmortem examination was possible with that knife. Exhibit 17 is my letter containing the said query. On my prayer,
my lord, this is very important. My lord, may kindly take note of and underline the same. On my prayer, the SDGM Rayagada sent the exhibits for chemical examination in his memo number 846 dated 10/5/93. My lord, may kindly see it was seized on 11/2/93.
3 months later.
Yes, I got the point. It has, but how it was kept under
what circumstances?
Nothing is there. Just a minute. That I can't say. Exhibit 18 is the office copy of the said memo. Exhibit 19 is the chemical examination report received in the case. I have stated so in my note. The chemical examination report is dated 16/12/93. That is there in the record. 16/12/93.
But this is a case based on direct evidence.
My lord?
This is a case, if you have eyewitnesses.
I'll come to that.
I'm just saying. So the basic approach.
I'll come to that because this has also got important bearing on the record of the case. 16/12/93, which is around 7 months after the alleged articles were sent to him. Though, and the report says, though the same has got blot stain mark, yet it is also silent about the extent of blot stains on it. That has been answered by this honorable court. In a case of this nature, my lord, kindly take note of it. My lord, 56, ballot, it is first decision on the point is aired at 56 Supreme Court, page 51.
Time period between which the sample is collected and sent.
My lord?
The time gap between.
No, my lord. Each state is to be correct. My lord, that language used by the apex court is the chemical examiner's report about the blot stain is slovenly and perfunctory, and we have noticed that with regret. The same slovenliness in the report of other chemical examiners in some other cases that have recently brought before us, the chemical examiner's duty is to indicate the number of blot stains found by him on each exhibit and the extent of each stain unless they are too minute or too numerous to be described in detail. Merely to say that the blood was detected on an exhibit, as this report states, is not enough. It may well lead to a miscarriage of justice, compelling judges to acquit when they would have convicted, the report being more revealing. We trust these observations will be brought to the notice of the chemical examiners in the country, not that they all act this like many give full and detailed reports as they should. This judgment of the apex court reported in 56 Supreme Court, page 51.
So in 70 years, no change.
Has been taken note of.
No, but in 70 years, no change, I said, as far as chemical examiner reports are concerned.
Ballot, that caution has been given by the apex court and this court also. Ballot, what I mean, that is, they are in the 2019 Bombay also have brought that this principle should be followed because ballot, a person is going to be convicted for life or death because 302 prescribes that. It should not be the court, they should not be so callous. Whatever you will do, that will be accepted by the courts and that will be done. Because for that reason, my lord, time and again, my lord must have gone through that judgment where the last case I had also given, followed the crime, had the proof. My lord, there should be cautious in each step what they are going to do against an accused to put him under peril. My lord, here, this view of apex court has been taken note of by this honorable court in 59/1985 CLT, Nimai Murmu versus State. And also, my lord, again, 1985, page 180, wherein it has been stated, my lord, by this honorable court, it has been observed, the most important fact which comes to the root of the case, that there was no evidence as to how the clothes of the appellant, the deceased or MOs, had been kept after the seizure. It is necessary and desirable that the police officer recovering the articles of the accused, suspecting stains of blood, should immediately take steps to send and evidence should be laid to the effect that it has not been tampered with till the articles were not sent to the chemical examiners for our analysis. In the absence of such precaution having been taken, and it cannot be presumed at a later stage, human blood had been put on the articles to implicate the accused. If the evidence of sealing articles is not produced, it has been held that the court may not place reliance on the discovery of the blood stains seized from an accused in the absence of any precautionary measures. This judgment has again been reiterated in another judgment in 59 at 85 CLT, page 488. Our case squarely also on the same line, my lord.
Yes.
Another most important fact, my lord, I have raised this point in number of cases, but it has not been answered. My lord, we see the evidence of the doctor. I will definitely draw my lord's attention to the evidence of eyewitnesses, but my lord, we see the doctor who has conducted postmortem. He is PW7, M.K. Sagar. 123, page 123, man. You got it?
Yes, yes.
Well, on 11/2/93, I was working as assistant surgeon at Rayagada Subdivisional Hospital. That day at 9:45 a.m., I conducted autopsy in respect of the dead body of B. Bhaskar Rao, son of B. Gangadhar Rao of Yadur Street, Rayagada town. The dead body was identified to me by Constable 1729 B. Das. He has conducted autopsy over the dead body, which was sent to him, which was produced before him by Constable B. Das. But this B. Das, the constable, has not been examined to say, I had gone to the doctor and handed over the dead body for our postmortem examination. Can it be taken to be the dead body of B. Das? That has been answered in an old case, Honorable Court.
I see.
But after that, well, though I have drawn the attention of this, my lord, in number of cases, well, maybe in a positive side, maybe in a negative side, let it be answered, my lord, again. Because that judgment is 1971. I'm preparing note, I'm in halfway, I could not complete it, my lord. I'll give the note. Volume 37, 1971, CLD, page 477.
But in the cross-examination of this doctor, did you ask him?
Yes, well, I'll say so, my lord.
Or the IO, somebody should have been asked about it.
My lord.
The IO should have been asked, or the doctor should have been asked. Think about criminal cases, we may have several questions, but
my lord may say so. That it's if that is to be,
it can't come up at the stage of arguments in an appeal. That
has been done in the stage of an appeal. I'm so many.
No, but a foundation has to be laid for that during the trial. That's what I mean.
Page 15, may see.
Yes.
15. Whether the book has been given.
Yes.
Book has been given. I'm just reading I will give the reference. It is next argued by the defense that there is no legal evidence of identification of the dead body of the deceased to the doctor who held the postmortem examination. This is by our ex-Chief Justice, Honorable Justice S.K. Roy and Justice Acharya. It is next argued by the defense that there is no legal evidence of identification of the dead body of the deceased to the doctor who held the postmortem examination. The doctor PW1 says the dead body was identified to him by the constable PW9. There the constable was examined. Here the constable has not been examined.
So the doctor was asked. There the doctor was asked.
I'm coming to that.
No. You just said doctor was asked, and then doctor said whether it was identified or not.
No, madam.
You just read that sentence, sir. Just read it again.
I'm reading it, madam. PW9 is the constable. Bironaik and another person, Simpson Lakra. This Simpson Lakra has not been examined. The constable PW9 merely says that he took the dead body for postmortem examination under dead body Challan Exhibit 5 and command certificate Exhibit 6. Here that is not there.
No, I'm on the doctor. There was a question put to the doctor in that case.
I'm coming to that part. He does not testify that he identified the dead body to the doctor as that of the deceased. The IO who drew up the dead body challan and the command certificate has failed to prove them. There is thus no evidence to show that Exhibit 5 and 6 were in respect of the deceased. Equally, there is no direct evidence by the constable that he identified the dead body which had been entrusted to him under Exhibit 5 and 6 to the doctor. There is thus a lacuna left to the prosecution in the prosecution evidence, as the postmortem report cannot be connected with the deceased. One of the facts in the issue in this case is that the nature of the injuries received by the deceased were, that is on facts. But here I'm coming to the evidence of PW 7. Nowhere it is there with regards to identification.
Yes.
When the deceased arrived at the hospital during that time, he was gasping, but a few minutes thereafter, he breathed his last. There was no other external injuries at the body of the deceased body, the dead body. So it is the duty of the prosecution, my lord, to prove the case beyond all reasonable doubt.
No, but he must create the
how, my lord, whether it can on this chief that the dead body was brought by the constable 1729 Bidas. What made them not to examine my lord that Bidas?
Yes.
He would have come and said, yes, I had gone to the hospital, I produced the dead body before the doctor and doctor for postmortem examination. It's not that, my lord, prosecution is to prove the case beyond all reasonable doubt.
Said was identified.
Who?
No. There's no problem. Yes, all right.
No,
all right.
My lord.
There's no problem. No, nothing.
But with regards to the evidence of the witnesses to the occurrence, my lord, before going to that, I just want to draw my lord's attention some facts which goes to the root of the case. How this case has been concluded. But if prosecution will think of that we will implicate A, B, C, D, and ultimately case can be cooked up. But there are in the process of cooking up the case, they left certain things which always help the prosecution, but defense. My lord. Here is a case. My lord, may see the evidence of PW 12.
Yes.
Father of the deceased.
Yes.
B. Gangadhar Rao, page 137.
Yes. Yes.
Paragraph 7.
Yes.
Instead of going to the chief, my lord, I'm drawing my lord.
Right.
Paragraph 7. I was present at the hospital for about half an hour. In my presence, police came to the hospital. I did not tell anything to the police at that time. But my wife had informed at the police station about the murder of the deceased. But this is the first information given by the wife of PW 12 with regards to a cognizable offense. It cannot be ignored, my lord.
Right.
There should have been a stationary entry in that respect. I was present with my wife when she reported at the PS. But that has not seen the light of the day, my lord. Many outsiders were also present at the PS at that time. But I cannot name them. I cannot say if police reduced the oral report of my wife into writing. My son wrote a complaint to Aichi Babu in my absence. The deceased was reading in college at the time of murder. I do not know if the house of Chinari Krishna is near the place of occurrence. On 9/2/93, I did not give anything in writing at the police station. Ballot. paragraph 8, 6th, 7th line, my lord, please see.
Yes.
I do not know if my wife charged the wife of Manda Raju as to why she got her son murdered and had their daughter married to her son, their caste would not have been lowered. That because that deceased was in love with a girl. Chinari Krishnan is Kubuti by caste and I am Kapu by caste. It is not a fact that on the following day of murder, our family members going near the house of Chinari Krishna charged them that they got my son murdered by others than the accused persons. It is not a fact that I had given the love letters of my son written by Swarna to the police. On 9/2/93 from so-and-so, I was present at Rayagada police station. It is not a fact that I have not stated to the IO that at about 1 p.m., while the deceased was returning home, all the accused persons along with 20 to 25 others had assembled to assault the deceased and stopped him near the house of accused Yaddu Kumara Swami. It is not a fact that at about 1 p.m. of 9/2/93, no such incident had taken place and I did not see any such occurrence. It is not a fact that my son was always moving with Gundas. I do not know if a week prior to this murder, the deceased was assaulted in the market in connection with the love affairs. It is false to say that subsequent to the assault of the market, myself and family members had picked up quarrel with the parents of Swarna, that girl married with whom this was in love. It is not a fact that no incident had actually taken place on 8/2/93 or 9/3/93. Let's see. Cross-examination, paragraph 10.
Yes.
At page 144.
Yes.
The deceased has kept a piece of paper. This is very, very important, my lord. The deceased has kept a piece of paper mentioning the name of the accused persons in his pocket. And police recovered that paper from the wearing apparel of the dead body. That father of the deceased says, deceased had kept a piece of paper written the name of the accused persons, which was seized by the police. Where is that letter, my lord? Why prosecution has suppressed that letter? That would have been taken as a dying declaration of the deceased. What made them to suppress, my lord?
It's unusual. Why would he write down names and keep it in his pocket? He doesn't.
That is the statement of PW 12, my lord. This is not a statement of a person who is outsider, who is against prosecution.
Yes.
That was seized by the police. He should have said, no, nothing has been seized. That was seized. But prosecution cannot suit the documents which you want to produce and which you will suppress.
I don't know if this, it is not a fact, also has to be...
I don't see the original.
Sometimes when the judge dictates...
The thing which that should be clear.
It could actually be, it is not a fact that the decision...
Not clear. From day one, the way we have read criminal trial, they should come with clean hands. They cannot suppress something, they can put something which will suit them.
Anyway. All right.
Let me see the original. I have no,
that's okay. That's okay.
Because that has been prepared by the prepared this paper book.
I know. LCR, just see the TCR is there.
Barcode, it's there. Let me see.
You can carry on. We'll meanwhile see it. You can carry on. You can carry on with that.
I have not read that paper. Next line, my lord.
Yes.
I have not read that paper. I was not present when my son was writing over that paper. It is not a fact that the police suppressed that piece of paper as it was not revealed the names of the accused persons. Well, that goes to everything, man.
All right.
Not a single sit. If that would have been produced by the prosecution, my lord, who are the persons, my lord, those who will say better with regards to the death of his own? He is the best person to say about the death of his person. What made him to say that, yes, that was seized?
Yes.
Correct. So, my lord,
No,
question is,
this is only one eyewitness, the father.
no. Other witnesses are present. No, my lord, law is, at least the way I have understood till date, my lord, prosecution is to prove the case beyond all reasonable doubt.
Correct.
Second thing, my lord, that when the prosecution has come up with a case, they will be always interested to see that the case will be ended in conviction. The duty of the defense is to give a parallel case where the court before whom the case is there, court will be in a position to think maybe case put forth by the prosecution may be true, may not be true.
Correct.
When question of may be true and may not be true comes up, the benefit always goes in favor of the accused. Not that the duty of the defense is go for a clean acquittal. No such occurrence has taken place. You have to raise suspicion in the mind of the court. Again, court has said suspicion, however strong, it cannot take the place of proof. Here, my lord, our endeavor here was to raise suspicion in the mind of the court that deceased had university before the occurrence for which he was moving with local gundaj. He was a young boy, college student. He was moving with nothing of that sort that accused persons had got any sort of inimical relationship earlier. They had family dispute. Family dispute doesn't mean that they will kill someone. He was in love with a girl, and family members, because it belongs to the caste problem, family members of the girl, they were not interested. And most peculiarity of the case is the dead body was found in front of the house of the girl. Neither the father has been examined, nor the girl has been examined when that was the case. And another thing which I had raised in the earlier case, the documents, there I had drawn my attention to the two provisions of the Criminal Procedure Code of 167 and 172 of the code. There, the duty of the police officer to produce the records each day. Well, after, sorry to say, I had raised the point, and when I again went through the barcode, taking the copy, I found that provision is not applicable to that case because the accused was not arrested. Here, my lord, the accused was arrested, and question has been put to PW 13, who is the investigating officer. Well, may kindly see, all these paragraphs are important because he, the officer who has investigated into the case and submitted charge sheet, paragraph 7, page 149. Lives like so and so. I arrested accused K. Srinu, B. Srinu, B. Govinda, and Uma Shankar after recording their statements. It is not a fact that accused persons did not lead me and witnesses and did not give recovery of any weapon of offense. It is not a fact that I seized some love letters given by one Swarna to the deceased from the house of the deceased, and I have suppressed those letters. it is not a fact that I seized a paper from the pocket of the deceased containing the names of the prospective assailant, and I have seized that paper as the same does not suit the case. That question has been specifically put to the IO. And definitely, when the IO is suppressed it, you will not say that, yes, I have seized. And but PW12, their father of the deceased, has admitted, yes, it has been seized. We do not know, my lord, we do not know what is the contents, but what may not to produce it. That raises, my lord, a doubt of Himalayan right, my lord. Not that, my lord, it's not a case of simple days. A has assaulted B, C has assaulted D. Not that, my lord. My lord, next, paragraph 8. BW3, so and so. So he came out from the medicine shop being called by 4 accused persons. He has not specifically stated to me that each accused person was examined separately and gave recovery separately. That has got, my lord, must have gone through section 27. That is the exception. Everybody knows, my lord, we all lawyers, we know section 1 part is inadmissible, part 2 is inadmissible. Sorry, first one is inadmissible, second part is admissible, leading to discovery is admissible. But when that second part is inadmissible, very rare, that is exception in section 27, my lord. If the joint statement of the accused persons have been taken before the recovery, that is inadmissible, that has been held by the appellate court and that has been relied upon by this honorable court in a single case, my lord. Sheikh Adamuddin versus State, that has been relied by Honorable Justice B.K. Behera, referring the case diary, madam. Referring the case diary, because there I was appearing along with my senior in case of Shemalad 87 or 88. The then ex-advocate general, my lord, senior advocate, my lord must be knowing, my lord Justice Das must be knowing him, Barrister Birendravan Patnaik. He drew the attention of the court. It was not there in the record. He drew the attention of the court that prosecution has deliberately separated the statement to make it admissible. Because we are appearing in that case for the informant. And honorable court was pleased to take note of the statement and made it inadmissible and acquitted the accused from the death sentence. He was sentenced to death because maternal uncle had killed the nephew.
Okay.
Because it was rest on circumstantial evidence. Well, the question was, he has not specifically stated to me, each accused was examined separately and gave recovery separately. Very, very important matter. That goes root to the case. House of Chinari Kasi Vishwanath is situated near the place of occurrence. He is a businessman. I do not know if he Vaishya by caste. I cannot say if Swarno is his daughter. I do not know if Swarno and the deceased were reading together in Rayagada College. I have not examined him as a witness, nor I have gone to his house during investigation. After affair was lodged and case was registered, I went to the hospital and not before that. I have not examined the mother of the deceased at all in course of investigation. It is not a fact that I had recorded the statement of the mother of the deceased relating to the occurrence prior to Exhibit 1. But before Exhibit 1, the version of mother of the deceased, wife of PW12, was recorded. But that has not been produced by the prosecution. It is not a fact that Exhibit 1 was prepared on 11/2/93, because there is a incorporation, a manipulation in the affair without any initial. 11 has been made to 10 to see that affair has been lost with all promptitude. PW1 has made the correction of the date. PW1 has made the correction of date appeared before his signature in the affair. Why he was allowed to correct ballot? And if he was allowed to correct ballot, it's there should have been some initial of the investigating officer or the IO or the person concerned who was in charge of the record. The date 11/2/93 has been corrected to 10/2/93. Well, it's not a simple piece of paper because entire case starts out of that. When that information opens a cognizable case, investigation starts with that. PW1 has not initiated.
Yeah. It's not initialed the correction.
Under the correction, it is not a fact that I have suppressed the fact that Sorno was willing to marry the deceased. It is not a fact generic Kasi Vishwanatham engaged some miscreants to kill the deceased. It is not a fact that the investigation was directed against the accused persons towards whom the informant had ill feeling. It is not a fact that my investigation discloses that the family of the informant had ill feeling towards the accused persons. It is not a fact that the accused A. Umashankar and accused B. Srinu did not give recovery of any weapon of offense. It is not a fact that accused B. Govinda Rao did not give recovery of any weapon of offense. It is not a fact that they did not give any statement. I did not say, because that statement is not available in the record. It should have been produced, it should have been exhibited. I cannot say if plow shares like MO2 are commonly available in the market. Immediately after seizure, a slip of paper containing the signatures of witnesses, accused and myself was pasted on MO2, but the said slip of paper is not found on MO2. I have not sent MO2 to the doctor. MO2 was not seized by the time PW2 was sent for medical examination. Knife recovered at the instance of the accused B. Srinu is not there in the court. I have not seized the wearing apparels of those persons who took the deceased to the hospital. Only 4 injuries which I have mentioned in the inquest report were noticed by me at the time of inquest. In the affair, PW1 has stated that accused M. Srinu assaulted with his knife on the chest and stomach of the deceased. It is not a fact that I have not seized the wearing apparels of the accused persons.
So we'll continue after lunch.
My lord.
I may be pardoned to mention that PIL along with some matters will be listed on 12th. It may be 13th because Learned Advocate General is absent on 12th. I'm giving the memo.
Item number 1.
So we were in 150, page 151.
Well,
We were at page 151. Paper book.
yes, madam. Well, I have folded it also. Well, say around 6th, 7th line. It is not a fact that that day did not give any statement. I cannot say if flower shares like MO2 are commonly available in the market. Immediately after seizure, a slip of paper containing the signatures of witnesses, accused and myself was pasted on MO2, but the said slip of paper is not found on MO2. I have not sent MO2 to the doctor. MO2 was not seized by the time PW2 was sent for medical examination. Knife recovered at the instance of the accused B. Stenu is not there in the court. I have not seized the wearing apparels of those persons who took the deceased to the hospital. Only 4 injuries which I have mentioning in the inquest put are noticed by me at the time of inquest. In the affair, PW1 has stated that accused M. Stenu assaulted with his knife on chest and to stomach of the deceased. It is not a fact that I have not seized the wearing apparels of the accused persons. 10. I have not mentioned the time of sending the affair to the court in the case diary. I sent the affair to the CSI through DAC book. This is very important, my lord. With reference to the said DAC book, I cannot say when the affair was sent to the court. I have not mentioned the exact time in the case diary when PW1 was examined under section 161 CRPC, but he was examined soon after the affair was lost. On 11/2/93, PW2, Kendara Srinivas Rao, PW6 so and so were examined by me, but I have not noted the timing of their examination. In between 12 midnight and 8 a.m., I examined B. Gauri Shankar Rao and...
Is all this important? This is all not important.
Not important.
Just read
all of them.
parts.
All of them were, after that, all of them were examined at the PS and SP was not present at the time of their examination. On 12/2/93, at 1 p.m., I forwarded 4 accused persons to court. Exhibit A is the forwarding report. I was asking bench clerk to see the records, but it's not there.
Oh.
Because, my lord, after that, my lord, why I wanted to see, my lord, the question has been, after reading the evidence of IO, my lord, I will say why. Exhibit A is the forwarding report, which I sent to the court. While
Cause list. It says here.
Barcode.
Where is that TCR? Hard copy. We're only talking about hard copy. Soft copy is available. Soft copy is available. Print it out. Print out the whole soft copy. Ask him to print it out.
On on 12/2/93, after 1 p.m., because perhaps this question was put because on 12/2/93, accused persons were forwarded. Whether while they were forwarded, these witnesses have been examined or not, their statements have been forwarded along with the forwarding report or not.
Okay.
That is perhaps that is the question.
Right.
And that is important matter for that.
Right.
I have not seen the parents of the deceased at the prior to lodging of the affair. I do not remember if the father or brother of the deceased reported about any incident prior to the occurrence without reference to the stationary entry book of that day. I cannot say if I made stationary entry number 203 dated 9/2/93 at 9:15 and 9:45. This is all evasive reply by investigating officer. It's not expected in a case of 302, my lord. I have not noted the situation of the house of Jami Janardhan in the spot map. Jami Janardhan is the father of that girl with whom my lord the deceased was in love.
Right.
And just in front of his house, dead body was found.
Right.
So how that spot, that is very important in the spot map, my lord.
Right.
It is a fact that PW1 has stated to me that he heard from Simanchal Patra and the deceased that occurrence, that accused Govinda, Srinu, K. Srinu, B. Srinu and Uma Shankar had quarreled with them and assaulted them near the shop of Jami Janardhan at about 1 p.m. It is not a fact that PW10 Simanchal Pujari was set up to support the prosecution and he was assured to be given a job. PW10 Simanchal Pujari has not stated to me that on 9/2/93 he was assaulted by any accused. Next, paragraph 11, my lord. My lord, relevant person, my lord, I am coming to paragraph. Just before paragraph 12, my lord, you see the gist of the affair has been entered in the stationery entry book. That I will say, my lord, at all. PW, because that is relevant while PW1's evidence will read, my lord. If my PW1 is the person who was initially detected affair to PW3 in Telugu. Paragraph 12, the place of recovery of MO1, 2 or 3 is accessible to public. The spring knife seized at the instance of accused B. Srinu is not found in the court. It is not a fact that another knife has been produced. It is not a fact. IO has admitted that spring knife is not there, but another knife has been given to be exhibited, to be given as MO. It is not a fact that no stationary entry has been made on 10/2/93 after receipt of affair relating to the incident by mother. That is not no stationary. It is not a fact that as such stationary entry will go against the prosecution case, the same has been suppressed. Exhibit B is the forwarding letter prepared by me while forwarding accused Y. Manmath Rao to the court. That can be verified from the records, madam. In connection with this case, PW10, Mr. Perry was examined by the SP Rayagada in my absence. He was examined by SP on 11/2/93. I do not know if accused Yadu Kumar Swami is working as assistant security officer in Jaipur Sugar Mill. Statements of witnesses Simanchal Pujari and Govardhan Patra have been written on separate papers and not in form of the case diary. Those sheets containing the statements of witnesses Simanchal Pujari and Gangadhar Patra have been attached with the case diary and they form part of the case diary. This next line is very important. I cannot say if for 9/2/93 any stationery was made basing of the version of the father or brother of the deceased. It is not a fact that I have not sent the copy of the case diary while forwarding the accused persons to court. So it can only be ascertained from the case diary. It is and forwarding report by it. It is not a fact since no case diary was maintained, the same was not forwarded to the court. It is not a fact that I have subsequently manipulated the case diary to suit the prosecution case. It is not a fact that in the house of witness Simanchal Pujari, I recorded the statement in presence of SP. It is not a fact that the accused Y. Manmath Rao, Y. Satish Rao, and Y. Kumaraswamy were not absconding and they were present in their house. This is not important. Important is, my lord, with regards to preparation of the case diary.
Yes.
That can be verified from the work code itself. My lord, I was drawing my lord's attention to the evidence of PW12, the father of the deceased.
Right.
That statement with regard that a slip of paper, the paper was written by deceased, was seen by the police. That has been confirmed by his own son, own brother of the deceased, son of PW12. I was verifying, and I have also stated, but I had missed. I could not say. Well, let me see page 121. PW6 is the brother of the deceased. (121).
Yes.
Paragraph 6.
Yes.
Second line, 121, top second line. It is a fact that a paper was seized from the pocket of the deceased by the police.
Okay.
I had also handed over a letter to the police which was given to my mother by the deceased. At least, my lord, they should produce anything. Why they suppressed it? That speaks volume, my lord, with regards to the innocence of the accused. They cannot ignore everything, saying that I do not know, I have not done this, that. Persons are facing trial in a case of murder. It's not a case of 323 or 324 or 325. Our life is in question. How could they ignore? How could they suppress all these things? As because that has not suited the prosecution. And my lord, vis-a-vis with my lord, at this juncture go to PW1. No, my lord.
Purna Chandra Rao.
My lord.
Another son.
Purna Chandra Rao. What? PW1. He has stated about the earlier dispute between the group.
This is the younger son.
My lord. One of these, my lord, elder brother, son of PW12. He has stated about the affair. If my lord will see, I have brought my lord's attention to the affair, and what my lord has found that the affair has been corrected. IO says, yes, it has been corrected. By whom it has been corrected? PW1, my lord may see evidence of PW1. This cannot be thrown away as it is, because my lord, each line in a case that is important, my lord. We cannot say that yes, X has said that Y has murdered, we will accept that. My lord, we see evidence of PW1, my lord, page 101.
Yes.
Paragraph 7, last 6-7 lines, my lord.
Yes.
At the time of lodging of the affair, I stayed at the PS. Got it?
Yes, yes.
For 10 to 15 minutes. While signing the affair, I did not make any correction or of the date. Then who has done it, my lord? He says, I dictated, PW3 has converted it to Oriya and handed over to me. PW3 says, no date was there. He says, no date was there. Then who has put the date and who has corrected it? And that has been exhibited as exhibit 1 by 1.
Yes.
No explanation for that, my lord. It's not an empty formality. It's a affair in a cognizable case. Day one, when we are a student of law, my lord, we are taught what is cognizable, what is not cognizable. And what is the importance of this lodging of information. And what is the sanctity of this, my lord. I did not put the date under my signature. It is not a fact that exhibit 1 was not written and prepared during the night of 10 to 93. So this vis-a-vis with the statement of PW13, the investigating officer, and PW6 and his father, PW12, it is so ballot a volume, so ballot what is the reason behind the implication of the present appellant's ballot. And another thing, ballot, the prosecution has relied upon some materials in the judgment which has not been put to the accused persons during trial. I just want to say, Exhibit 19 is the chemical examination report. If, my lord, they want to use that chemical examination report against the appellant, that question should be put to you, accused, my lord, as stated in Section 313 CRPC, Section 313(1)B. Unless that question will be put and has been duly answered, that cannot be used as a material against the accused, my lord.
Yes.
My lord will see B. Srinu and B. Govinda, accused statement. My duty to draw my lord's attention to all the materials of my lord to decide.
Which page, sir?
My lord, that is page 44.
Yes.
Let me see. whether any question has been put with regards to Exhibit 19. Then how can that be used? It cannot be used against me.
Yes.
With regards to B. Srinu and B. Govinda.
Yes.
Now, that question has not been put. B. Govinda, my lord, B. Govinda is page 75. No question is there with regards to Exhibit 19.
Yes.
But at this question with regards to Exhibit 19 has been put to M. Srinu as question number 27. My lord, see. M. Srinu is at page 64. Last question is, my lord, page question number 27. It is revealed from the chemical examination report, Exhibit 19, that the knife which was seized at your instance was bearing stain of blood. This question is absolutely wrong. But let me see Exhibit 19. No blood stain was there.
Okay.
How this question can be put and be used against me, my lord? Well, if my lord will see Exhibit 19, that is the chemical examination report, my lord will see the report under Exhibit 19 shows that no opinion could be given with regards to the blood on knife marked as N, as the same had deteriorated. And how the court has used it against Ross Parrott.
But isn't that section 293 or something in the
293
CRPC that scientific reports? Yeah.
But opines, my lord, if it would be something will be accepted without any controversy. During trial, my lord, what used to trial court used to say, these are the things which will be, I'm taking it as exhibit without any objection. But that ballot is perhaps referring to 294. No proof, verbal proof of certain documents.
Right.
That document has been proved. Who says no, my lord? But the contents of the document, as depicted, as stated in 313, that is wrong. My lord, may see question number 27.
Yes.
My lord, Supreme Court has time and again has deprecated this practice because I am in the dock. These are the materials available against you that should be put to me and to give answer. And if the question will not be put to the accused, then, my lord, that material which has come against me cannot be utilized against me. That is the law. Till date, that is the law. My lord, here the question is a wrong question, my lord. That is, my lord, Govinda, 75 to 84, my lord, we'll see. Sorry, my lord, that is
75, Govinda.
No, sorry. 74.
Page 74.
My lord. Reveals, question number 27, it is revealed from the chemical examination report that the knife MO1, which was seized at your instance, was bearing stain of blood. My lord, you will see exhibit 19. It's not, it's rather says, my lord, no opinion could be given with regards to the blood on knife. And what would be my explanation? I am not an expert. I said, Michot. It's lie. And that, how that has been used against me? Well, on the face of the entire gamut of this occurrence, my lord will see, each step prosecution has tried to develop their case step by step to put the present appellants, to put present appellants on gall. How, my lord? You see, occurrence, there was admittedly a dispute between the families. That doesn't mean that we will kill because we have got antecedents. No, nothing is there on record. Rather, materials are brought to the effect that the deceased was in love with one girl. The family of the girl was seriously opposing it. Some love letters have been seized, that has been suppressed. They cannot suppress everything only to prove the case against the appellants. That was seized, that has been suppressed, and my lord will see DW1 and the evidence of DW1 and DW2. Witnesses, those who are present, independent witnesses, those who are present at the spot, they have heard deceased was shouting, because this occurrence is at Rayagada. Perhaps the accused persons, those who had assaulted, those who were there and have assaulted the deceased, they belongs to Wadipatta. That is there. Well, the scale of appreciation with the evidence of defense witnesses as well as prosecution witnesses is same. And no cross-examination in that aspect is there by the prosecution. If, my lord, a case can be cooked up against me today, and persons, those who are present in the court, they will say, yes, Mr. Dhal has told me this. So a case is there, and I will be taken as an accused. Bereft of the fact that my lord will say, no, he was arguing before me. Different. That is there, my lord, in this case. When I have said everything, my lord, I will prepare a short note.
All right.
May it please the lordships.
Yes.
My lord, at the outset, my lord, with all humility and my respect to my learned senior, Mr. Dhal, well, there are some grounds that Mr. Dhal is coming up with, my lord, that is regarding suppression of some letters from the pocket of the deceased, serological report, the lactona in it, the improper recovery of weapon of offense, motive which is attributed to another person regarding the affair with a girl, my lord. Well, all these things will become relevant or will come to the forefront only when it is a case of circumstantial evidence, my lord, where each link has to be properly explained and there has to be a very comprehensive and cogent circumstantial link, my lord, to bring the complicity of the... This is a case where there are eyewitnesses, there is a different motive which are attributed to, and my lord, eyewitnesses corroborating the ocular witnesses corroborating the medical witnesses, my lord. In this aspect, my lord, and my lord, first and foremost, I will just, there was a question I was asking myself, and which the Honorable Apex Court has also many times asked, that why should the related witnesses or the interested witnesses implicate some innocent persons when they know that and try to, they try to shield the actual assailants and implicate some innocent persons. So that is the first and foremost question that comes to my mind, my lord. And I would. So in this context, my lord, first and foremost, I'll take your lordships to PW1 evidence, my lord,
yes,
which is a direct corroboration of the medical evidence.
No, the other way around. Medical evidence corroborates what this witness is.
Pardon, my lord?
It's the other way around. The medical evidence corroborates what this witness is saying.
Yes, my lord. So, my lord, should I read that PW1?
Yes, read it, but you can read it.
My lord.
Yes.
My lord, I will only try to take your lordship to the second page of the PW1, my lord.
Right.
Regarding the injuries, my lord, and vis-a-vis, I'll take your lordship to the doctor's witness, my lord. My lord, I'll start from accused Mehdi Sinu was armed with a knife having wooden handle. Accused, your lordship got it, man? Accused Bobili Sinu was holding a spring knife. Accused Govinda was holding an iron chain with which cows are usually tied. Accused Uma Shankar was armed with a plowshare. Accused Govinda caught hold of the shirt collar of the deceased Bhaskar, who surrendered before them, raising the hands. At that time, accused Mehdi Sinu stabbed on his left chest, that is injury number 1, right side abdomen, injury number 2, by the knife, causing severe bleeding injury at both the places. Accused Bubli Sinu stabbed on the right side abdomen. My lord, these are the 3 injuries. I'll take your lordship to the doctor to show that there were 3 corresponding injuries, my lord. One, at page 123, there's the doctor's evidence, my lord. The one is size of the injury, spindle set piercing wound, above and lateral to the left nipple. Size of the injury was 1 into 1 into the middle of the chest. Second is a spindle set piercing wound right to the Ziphy sternum. Ziphy sternum, as your lordship note, is in the middle of the sternum, my lord. The injury was traveling upwards the chest. That is the second injury. Third, a spindle set piercing over the middle of the costal margin, my lord. Costal margin, as your lordship note, is just near the sternum, my lord. Traveling towards the middle of the abdomen. So 3 injuries cited by the eyewitness, and there are 3 corresponding injuries, my lord. Then, my lord, I'll continue from the PW2. Accused Govinda, winding up the chain around his hand, gave fist blow on the mouth of the deceased, in consequence of which the deceased fell down on the road. No other injury was found on the body of the that is there. So this fist injury was not probably that strong with that much of strength. So it has given any. It has left any mark.
May I interpret? One thing, my lord, death is not disputed. Injuries are not disputed. Only how far they will be believed. Witnesses will be believed considering the surrounding circumstances. My learned friend may answer that. Why that affair has been manipulated? What made, my lord, suppression of the letters? That is, my lord, criminal. Again, I am repeating, my lord. My learned friend was arguing a case against me in 2019, decided by Honorable Justice B.N. Prasad, and same question he has read. Why this informant will be received disbelieved while when he has received 20 injuries? But the receiving injuries and lodging information, that is not important. Important is why, under what circumstances, whether he will be believed or be disbelieved. Again, my lord, I am repeating, my lord, in criminal case, not that, my lord, injuries are available, I have stated so, that is surrounding circumstances, cumulative effect of surrounding circumstances will be taken note of.
Letter.
Why am I referring to this PW1 and the injuries, my lord, to show that there's some credibility in the statement of the PW2 that he has actually seen the incident. Then, my lord, that is why I'm very carefully reading, my lord. He fell down. Thereafter, accused Uma Shankar Rao tried to assault the deceased with a plowshare. At that time, as I raised my hand, the plowshare, which was looking like an iron rod, hit on my right shoulder. My lord, he is an injured eyewitness. He has been examined by PW5, if I'm not mistaken, my lord. PW5 is another doctor who has examined this injured eyewitness. I raised my hand to protect my elder brother who was lying injured on the road. So he has sustained injury at that point of time. Kochanda Srinu and B. Suresh took the injured to the hospital immediately by a scooter from the spot. The government hospital is about less than 1.5 kilometers from the spot. I went to the hospital running. By the time of my arrival, my brother Bhaskar was dead. Thereafter, I came to the Raigad police station. My lord, this has happened in such immediate, within losing any time. So where is the time of any manipulation of the affair, my lords? 9:30, the incident occurs. They have rushed to the, and the affair has been lost in the police station, my lord. My lord, if I'll and most importantly, my lord, all the questions that my learned senior is posing before the lordships has been answered very clearly by the learned court below. But nevertheless, I'll also make my effort to bring it before your lordships.
Right.
Then, my lord, there is a very specific motive, my lord. Regarding the affair with the girl, my lord, none of the family members have come up with it. Again, that is the reason, my lord. Had there been a very motive regarding a girl, why should the family members have absolved the real assailants and implicated this innocent person who have nothing to do with him? If they have no motive, why will they just what is the reason? What could be the reason behind shielding the real assailants? That the defense has not come up with that explanation. So coming to PW2, my lords, and all these PWs, they are related witnesses, and that is why they have said regarding the previous occurrences. The occurrences have started from 8th. 8th, there was an occurrence. 9th, there has been occurrence, and it has continued and ultimately culminated in this murder on 10th. FIR has been lodged on 10th, it has been dispatched on 11th from the police station, my lord. Coming to PW2, my lords, he is also an eyewitness. PW2 is Kachanda Srinivas Rao, my lord. He also is an eyewitness. I will just take your lordship to the relevant part. He has also specifically named all the accused persons, 4 who have assaulted. Made these reduce, B. Srinu, Uma Shankar, and Govind came to. They asked the deceased as to why he abused them yesterday. There was an exchange of words between them. Many people gathered there. The deceased raised his hand and told the accused persons, if they intend, they might assault. Accused Govinda showed the chain MO3. I caught hold of Govinda. Govinda pushed me aside. I moved a little. These are all witnesses who have participated in the occurrence, has been saved of an injury, of course, my lord. I moved a little. At that time, accused M. Shinu caught the shirt collar of the deceased. Accused Govinda attempted to assault the deceased, but I caught hold of him. Accused M. Shinu, removing the knife M1 from his pocket, pierced into the abdomen of deceased, causing serious bleeding injury. I have not seen when the accused other persons did. I have not seen, he very candidly says, I have not seen what the other accused persons did. As the deceased fell down due to assault, As the deceased fell down due to assault, PW1, myself, and T. Suresh took the injured to the clinic of Dr. YG Venkataramana, but he was absent, and as such, we took him to the hospital by a scooter. The injured died by the time we reached the hospital. In the cross-examination, my lord, regarding the there is nothing regarding the motive part. No cross-examination to PW2 regarding the motive part. Then, my lord, PW3, my lord, he speaks of the previous incident, my lord. He is known to the family. He speaks of the previous incident, how there was an altercation between the family. My lord, some of the witnesses are very categorically said that there was enmity between the two. There was some altercation where these people have said that we will do away with your life.
Right.
They said we will kill you. That is the word which the father also says, the brothers also says, that they have categorically come to the house and stated that we will kill because he has intervened in some. That is why I want to read PW3 before your lordship. I know the accused persons, and this is Bhaskar died on 10/2/93. On 8/2/93 in the evening hour, I was witnessing television in the house of deceased Bhaskar Rao. Trinath, the elder brother of the accused Govinda, was abusing the parents of the deceased. At that time, Bhaskar went to ask Trinath about reasoning of his abusing. I accompanied him. The deceased asked Trinath as to why he was abusing his parents in filthy language. Trinath gave out that his deceased parents caused his marriage proposal to be cancelled, and so he was abusing them. This is a motive that all the family members have spoken about. Trinath further said that why he came to ask him as Dada, and so saying he gave a push to the deceased. I intervened and the disturbance at that night was subsided. While the deceased, myself, the members of the family of the deceased were coming back to the house of the deceased persons, namely Shrinu, Govinda, Umasankar, gave pushes to me and Bhaskar. However, the matter subsided and we came into the house of the deceased. This is on 8/2, my lord. Again on 9/2 at 5 p.m., accused M. Shrinu, B. Shrinu, Umashankar and Govinda came to the medicine shop where I am working. They called me and came out from the shop. They told me that they would kill Bhaskar and I should not mix with him. But I advised them not to pick up a quarrel. That day, at about 9:40 p.m., I went to the house of deceased Bhaskar. But I disclosed there were facts before Bhaskar. Bhaskar also told me that at that time that aforesaid 4 accused persons were threatening him to assault and there would be no further trouble as the matter was compromised at the PS at the intervention of his father. Now, the father has also stated regarding this, there was some altercation, they had gone to the PS and matter was compromised in the PS. Father also has spoken of this. Again, my lord, he says, continues, on 10/2/93, at about 9:10 p.m., a boy came to me and informed the Bhaskar was assaulted and removed to the hospital. He has chronologically given the dates, my lord, 8, 9, and 10. Then I went to the hospital and found that Bhaskar was dead. PW1 was present at the hospital along with Purnachandra Rao, T. Suresh, and many others. PW1 at the time disclosed before me that the aforesaid 4 accused persons named Evab assaulted his brother at the Chak in front of the clinic of Dr. Y.R. Rao. I went with PW1 to the PS where PW1 orally reported about the occurrence in Telugu language. I interpreted his version in Odia. These are not relevant. So this has happened in a Chak in front of the doctor's clinic. I don't know if the doctor if the learned senior is repeatedly saying is in front of the father, in front of the girl's house. But my understanding is this incident has happened in front of a clinic of a doctor. Then continue, my lord. On 11/2/93, but he has, my lord, this is the recovery part, my lords, that which accused person has given recovery of which. But that I will also not harp on this because as long as I am relying on the eyewitnesses version, my lord, the recovery has been there. 3 MOs are there before the honorable learned court below. So, and serological report, yes, my lord, I will admit that serological report is not very conclusive, but there is from one Umasankar, the blood stain on Umasankar's apparel and the knife are of the same, my lord. Right. Then, my lord, para 4, 5, and 6 are regarding the recovery. If your lordship will ask, should I read the cross-examination, my lord?
No, why don't you make the point and then then read it. You first make your submission, then you can read.
Yes, my lord, my submission is that there's a very clear motive. Regarding this motive, there is a chronological events which has happened. This is not an event which has just happened, or these are like it has been put out to the defense that there were some Kolahandias who have come and he have assaulted him. There's a motive. There have been occurrences earlier to the incident, which has, like I said, which has culminated in this homicide, my lord. Where an eyewitness to this effect and the ocular evidence is also corroborative, my lord. Second, my lord, even there's a friend of the, my lord, PW9. No, I'm sorry. PW10. He is also a friend of the deceased, my lord. He has also chronologically seen how this enmity has gone day by day and it resulted in this. He has also very clearly explained from the beginning how they have gone to the accused and asked them, confronted them, how the accused have threatened. All these have been explained by PW9, my lords. So, my submission before your lordship is that all the eyewitnesses who have seen the occurrences have also dealt with the previous occurrences. There was a very cogent reason for them to do away. They had threatened this deceased that they will do away with his life because he was probably behaving in a dada manner. Right. So that is the motive that has been attributed to the accused persons. The rightly, my lord, there were 7 accused persons. 3 have been acquitted because their presence was not there by the learned court below. So the learned court below has said that these PW1, 2, 4, their versions are unshaken. Even in the cross-examination, their versions have not been there. They have not been broken. They have been very clear and credible, and that is why the Leonard court below has sustained the conviction on the basis of these eyewitnesses. And regarding the other part, my lord, why the FIR was, my lord, I was also going through the FIR, my lord. It's a mistake, my lord. All the events are of 10. Only one, he has just, by mistake, he has written 11, and that has been corrected as 10. It is not that it is antedated or posted, something like that. All the occurrence is admitted on 9th. All the eyewitnesses say that it was 9th night, it has happened. Sorry, my lord, 10th night it has happened. So where is the occasion of lodging the FIR in 11th, my lord?
Yes.
And it has been dispatched on 11th morning to the court.
Right.
And regarding the serological report, my lord, it's a delay. Yes, my lord. And it is inconclusive, my lord. But here again, I will reiterate, my lord, these are prosecution lacunas that should not come in the way of the conviction, my lord.
Right.
And all this that is liable to be answered by the IO, my lord. So just because the IO was callous or he was not diligent enough to deal with this, my lord, the prosecution case should not suffer on that basis.
Oh.
So I am harping on the eyewitnesses version, the injured eyewitness version, and the very specific motive and the chronological events that has preceded the occurrence which has resulted, and the medical evidence, my lord.
All right.
Injury to the vital parts, my lord.
All right. All right. Yes, Mr. Dar.
The questions which I have raised by Lord has not answered. Question I have raised, my lord,
One was identification of the dead body.
My lord?
Identification
No,
of the dead
I'm not on that. With regards to, my lord, evidence of PW 6 and 12, those who are related to the deceased as brother and father. With regards to the seizure of papers, and why that has not been produced, that she can answer. Is it was not required to produce? We can do only what the things which you want. Then I have nothing to say. My lord, second question, my lord, it has not been answered. That the question which has been put to the accused with regards to Exhibit 19, whether, my lord, I have got Supreme Court judgments, I will give it in my note. That is not mandatory, then I have nothing to say. Because, my lord, as per her submission, my lord, when PW 1, 2, 3, 4, or any witnesses, those who have stated that occurrence has taken place and X, Y, Z is the accused, that is to be accepted because that corroborates the injury. But I feel, my lord, I believe till that the knowledge, my knowledge on criminal law codes, it depends upon appreciation of evidence. So our entire gamut of the occurrence is to be taken into consideration, my lord. Not that witnesses have, like parrot-like stated, A has killed, A has stabbed, so A is to be convicted. It is to be seen with the background, my lord. How and under what circumstances, my lord, this occurrence has taken place and why they have been taken as an accused.
Right.
My lord, IO has tried his best to avoid the entire questions which have been put. And this last, my lord, I am not in a position to say, my lord, the questions which have been put to IO, my lord, Exhibit A and B, my lord, has also not answered with regards to this forwarding report. That has got very far-reaching consequences, my lord. I was drawing my lord's attention in the last case, 2020 OLR of Honorable Justice Kaul's judgment. That has got a very far-reaching, my lord, effect with regards to veracity of the prosecution case. That only can be obtained, my lord, for opening barcode, because now earlier what we are doing, we are verifying the LCR and system has been changed where we cannot open the barcode also unless without being permitted. So these questions, because that has been put by the defense. That has been put by the defense. There must be something, my lord, in paragraph 12 of PW 13.
Right.
I could not verify that, my lord. I cannot substantiate that from the records.
All right.
My lord, can I answer to his question? My lord, regarding the paper, my lord, if I take a lordship to the cross-examination of the father, he says that I was not present when my son was writing over that paper. So he has no clear idea. Yes, it is written the last 144. The deceased has kept a piece of paper mentioning the names of the accused person in his pocket. And the police recovered that paper from the wearing apparel.
Where is that?
No. This is what's saying. Maybe that was not relevant. It had nothing, my lord, because the next line that the father says, I was not present when my
I have
son.
not read that paper. I was not present when my son was writing over that paper. It is not a fact. PW6, vis-a-vis PW6.
No, my lord, since that there was a series of occurrences, my lord, this goes against.
My son means my lord deceased. There he means my son deceased. And PW6 says my deceased had handed over a sheet of paper to my mother. Mother had given to me. I gave it to my father. But
so, my lord, that part had written, had the deceased been alive, he would have explained it. So now that deceased is not there, my lord. So this. So
that will be presumed against the accused.
No, my lord, because the next paragraph, the father says that he had no idea what was. He has not seen the paper. He has not seen what was written.
We have also not seen. You have also not seen.
So the prosecution and not wisdom.
Only my lord, suspicion can be raised only this much. Because suspicion, however strong, it cannot take the test of proof.
My lord, at the outset, there is no suspicion, there is enough evidence to
All right. We say orders reserved to be open to both parties to file the respective notes of submissions within a week. This will make sure that the printout is made available to you.
Well, before I prepare my note of submission.
Yes. Today itself.
Okay.
All right.
Weekly list item number 2.
2 may be taken up some other day.
All right. It will remain on board, sir. It will remain on board.
Well, let it remain on the board.
Item number 3.
2-3 councils are there along with me, but yes. Yes, Mr. Padhi.
I am for the appeal number 1 and 3, my lord. But so far, tomorrow is concerned, I have sessions case also at Puri, my lord.
Don't worry, sir. One of you, if you want, you can begin today. He can argue tomorrow. You begin today, sir. We are very happy to listen to you. You have come all the way. So you can start.
My respectful submission
vigilance,
my lord.
Available in barcode.
So far
they should either make it available to us here, or so that they can see it, or they'll have to print it out. Is there someone from the computer branch there sitting?
Well, in this I'll answer tomorrow. He will let him finish today.
Yes, sir.
Let's start. And for the appellant number 1, Seshadeva Swami, as well as appellant number, my lord, that is appellant number 3, Sonia Samal. My responsibility with due diligence, my lord. So far the case is concerned, my lord, the murder case alleged to have involved under section 30 as well as 34 IPC, my lord.
Yes.
So far the alleged occurrence is concerned, my lord, the alleged occurrence was held on 16th September 1991, my lord. And so far the judgment is concerned that was came into light on 20th August 1996, my lord. So far the present petitioners likely appellant number 1 and 3 are concerned. The appellant number, my lord, 3, Sonia also got bail from this Honorable Court, my lord, on the November 16, 2006, my lord. And so far the appellant number 1 is concerned, Seshadeva Swami is concerned, my lord. He has also enlarged on bail by this Honorable Court, my lord, on the month of February 2005, my lord. However, both accused persons already completed more than a decade in custody, my lord. And my responsibility with due diligence, there are six appellants. Those have also convicted under section 302 as well as 34 IPC as per the judgment passed by the Learned Additional Sessions of Khordha, my lord, dated 20th August 2096, my lord. My responsibility, other 20 accused persons, they have also charge sheeted and made a trial, my lord.
they got acquittal, my lord. And all the accused persons, they have also charge sheeted under Section 3 of the SC/ST and Prevention of the Atrocities Act, my lord. And all have also so far Section 3 is concerned, that was not made out, my lord. And so far as the prosecution story is concerned, my responsibility with due diligence, my lord, there was a village fiction or there was a village rivalry exists among the two groups, my lord. The one group is led by the deceased Rabindra Kumar Swai, another that is the prosecution party, my lord. The another also led by some other villages, my lord. So where the alleged occurrence is concerned, the alleged occurrence held on 16th, my lord, August 91 at about 4 to 5 p.m. And it is a matter of fact to explain before your lordship is that, my lord, the accused, the deceased Rabindra Swai, as well as, my lord, that is Kubera Jani, are also searching a field survey. And they left the place towards some village, Chokka Singh, my lord. Chokka Singh, my lord. And when they did not come at about 4 to 5 p.m., my lord, the suspicion arose in the mind of the Ukraine brothers, happens to be PW1, Gollega Swai. And he also, the Gollega Swai, also tried to search towards their presence where they are also. Accordingly, the PW number 1, Gollega Swai, as well as the PW number 4, that is the Vijay Kumar Patnaik, as well as PW number 3, that is Raj Ranbir Singh, my lord, they also prosecuted to search about the existence of that is the deceased Rabindra Swai, as well as the Kubera Jani, my lord. And when they went to the village, Chokka Singh, my lord, they also came up the Valerie Hill, and they came out, they also meet the PW number 3, my lord, Raja Ranbir Singh, my lord, who explained about the accused, my lord. He stated inter alia that accused person being armed with the deadly weapons, my lord, likely sword and cutlery, he has seen them prior to 1 hour of the occurrence, my lord. That he explained at about 2 p.m., my lord, on that day, my lord. So accordingly, the PW number 1, PW number 3, as well as 4, they proceeded to the Valerie Hill, my lord, and in some distance, the PW number 1 came to know that the feebling voice of his brother, my lord, that is Rabindra Kumar Swai, my lord. And he came to know by that time, Rabindra Kumar Swai shouted that, don't kill me, my lord. This is the incident which was happened at the Valerie Hill, my lord, near the Dalkai Thakurani, my lord, and they come up nearby the Dalkai Thakurani, they came the patch of the blood stain, my lord. And accordingly, though even was occurred, my lord, they did not proceed and they came back and they intimated the matter to the APR force. It is a fact that the APR force was engaged prior to the occurrence in the village of the Pratap, where there is a dispute exists between two groups, my lord. And they reported the matter to the APR force, my lord, and also reported the matter before the PW number 16, my lord, that is the IO concerned, my lord. And on that day, no further proceeding was to continue, my lord. On the 7th, at about 2 p.m., being received the information given by my lord PW1, PW 16, and other man means PW4, PW3 proceeded to the Valerie Hill, my lord, with the torchlight as well as, my lord, another light too, my lord. And they came to that nearby the Dalkai Thakurani, my lord, the dead body of the Kubera Jani was found, my lord. And after some extent, they also got the dead body of that is Rabindra Kumar, which was beheaded, that was severed, my lord. This is being the incident, my lord, so far the prosecution story is concerned. And to defense, so far the case is concerned, my lord, 18 witnesses already examined and cross-examined before the trial court, including all the material witness, that is the material was likely PW 16 as well as PW 17, that is the doctor. My responsibility, this is being a case of the homicidial and the cause of death by means of a cotari mile. And your lordship know it very well that so far as the circumstantial evidence is concerned, I am also just saying one thing, my lord. In pursuance to reported decision 2011 volume 1, acquittal Babu versus State of Kerala, my lord. In case of the circumstantial evidence, my lord, in case of the circumstantial evidence, the burden duty of the prosecution has a greater duty, my lord. Prosecution has to establish the case beyond reasonable doubt so far as circumstantial evidence is concerned. However, in a circumstantial evidence, if the presumption is guilty stands in favor of the accused, then, my lord, reasonableness as well as liberty must have been given under Article 14 as well as 21 of the Indian Constitution, my lord. So far as the my lord, responsibility with the due diligence, so far as the circumstantial evidence concerned, my lord, it is a fact, my lord, though 18 witnesses already examined before the trial court, my lord, and so far the PW number 1 is concerned, my lord. My responsibility, that is Gollaga Swai, the brother of the deceased Rabindra Swai, also informed of the present case. And so far PW number 2 is concerned, my lord, Damodar Swai is also witness to the inquest, my lord. And so far PW 3 is concerned, Rajbali Singh, who accompanied the PW 1 and the nephew to search out the incident, my lord, that is the Babu, who was not also examined. So the Babu, which was accompanied with them also, was not examined by the prosecution agency, my lord. That is the great lacuna of the prosecution, my lord. Then my responsibility, so far as PW 4 is concerned, Vijay Patnaik also accompanied to the spot, my lord, along with the PW 1 to search the deceased, that is Kuber Jani as well as Rabindra Kumar Swai, my lord. So far PW 5 is concerned, Ananta Maharana is also stated to have seen the appellant near the narrow of the foothill of the Valley Hill. So far as PW 6 concerned, Vidyadhar Swai stated to have heard Rabindra Swai telling one Pramod Mansingh from getting Halia at that the time of the appellant Sahadeva was present in the shop. So far PW 7 is concerned, he inter alia stated that Bhikari Swai stated that on the previous evening on the occurrence, he had been to Valerie Hill along with the Bhikari Behera and Satya Behera. He found the appellants were standing together and discussing something, having pleaded the appellant Sahadeva and Vasudeva told to they are here that they would play football with the head of the Rabbi Swai as well as Mahadev Dole, my lord. So far, PW number 8 is concerned, my lord, his role inter alia that Mahadev Swai is the witness to the extrajudicial confession, my lord, stated to have been made by appellant Sahadeva Swai and Vasudeva Swai. So far, 9 is concerned, Mahadeva Dole is a witness to the seizure of the one lungi and a red color napkin 112 from the house of the Vasudeva Rautra. He is also a witness to the seizure of one lungi and a towel in the house of the accused Kailas Swai. He is also a witness to the seizure of the accused Sonia and Sanatana Sambu. So far, PW 10 is concerned, Bhaskar Swai is a witness to the inquest, my lord. So far, PW 11 is concerned, Shiv Kumar Patra is a witness to the seizure, did not support the prosecution case. Though the case is based on the circumstantial evidence, each circumstance each have to be proved. And so far, circumstance is concerned, circumstantial evidence concerned, that was not also scanned properly by the learned trial court. And so far as PW number 10 is concerned, so far as PW number 10 is concerned, as well as other PW number, that is my lord, the PW number 2 is concerned, they are also not supporting the prosecution case. And moreover, PW 11, Shiva Kumar Patra is a witness to the seizure, did not support to the prosecution case. As my lord, so far PW 12 is concerned, Bahani Das is a witness to the leading to the discovery. So far, section 27 is concerned, one party is the confection, another is leading to the discovery. So for discovery, he stated to Kothari have been having a handle with 3 knot was also seized from the house of the Sahadeva, but PW number 16 also stated that it has been seen from the house of the accuser. That is my lord, Sahadeva Swai, my lord. Then my execution. So for the PW number 13 is concerned, Anita Swai is stated to have the meeting held by the accused persons proceeding on the date of the occurrence. So far, PW number 14 is concerned, Kaila Swai is a witness to the seizure. 15 is a director, D. Jana, medical officer, conducted the postmortem report of the deceased, and PW 16, 17, 18, and are the IOs, and PW CW1 is the PC Pradhan who has been examined on behalf of the accused persons, my lord. So my response submission with due diligence, my first submission before the honorable court is, so far as circumstantial evidence is concerned, that was not scanned properly by the law and trial court. This is being my the first submission before this honorable court. And so far as my lord, circumstantial evidence is concerned, with due diligence, I humbly submit, my lord, the factual scenario as projected by the prosecution does not establish the guilty of the accused, and the circumstances only highlighted. So far as the circumstantial evidence is concerned, that was not prove the guilty of the accused persons, and it was only highlighted by the prosecution to, my lord, to establish the case does not present, my lord, completely chain of the circumstances to warrant any interference in any conviction. So far the present case is concerned, in the first instance, there was not properly scanned. So far the circumstantial evidence is concerned. Secondly, my submission before the High Court, before this honorable court is, so far the circumstantial evidence that was only highlighted, my lord. And there was no guilty of the intention of the accused proved, my lord. Then my response submission with due diligence, my lord, so far as case is concerned, my lord, it is the fact that so far the present appellant number 1 and 3, both are concerned, both are already completed more than 10 years in custody. Then my response submission before the honorable court is, so far the factor is concerned. One thing, the circumstances are not properly scanned. Second thing is the factor, my lord. So far the factor is the essential ingredients to establish the, my response to establish the case based on circumstantial evidence. The factor is the key relevance, my lord. And it is a fact that although there is no eyewitness and the case is purely based on the circumstantial evidence, and my lord, so far as the factor is concerned, my lord, the factor is concerned, my lord, law and trial court has not also given importance or has not also given strengthened so far the factor is concerned, my lord. In which factor the case was occurred, what is the cause for creating such occurrence, my lord? These factors are relevant to this case, my lord, because, my lord, the fact that though there was a village faction and there was a village rivalry existed among the two groups, my lord, though APR force was engaged at the spot, my lord, the factor is the main things, my lord, attributed the case, the law and trial judge, my lord, failed to explain, failed to analyze the factor. So who is the factor? What is the cause? What is the real factor to strengthen the occurrence or to come into the occurrence is spot, my lord. Then my response submission before the honorable court is, my lord, my lord, so far a factor is concerned, I humbly submit with due diligence in my grounds, my lord, para C, my lord. For that, in case based on the circumstantial evidence, the time factor is one of the essential ingredients to be kept in view while dealing with a such type of evidence. In the instant case, according to PW1, his brother Rabi Swai, along with their field servant Kubera Jani, left our village Chakka Singh early in the morning, that is at about 7 a.m. PW1 went to their search at about 4 p.m. of that day. At about 4 to 4:30 p.m., PW1 meet the PW number 3, Rajwali Singh. PW 3 told PW1 that he had seen the occurrence, seen the accused persons at about 2:30 p.m. going towards Chakka Singh. So this is being the time factor, my lord. The time factor is the essential element. The law and trial court did not embark upon it, my lord. Then my response submission before the honorable court is only the PW1 in presence of the PW3 stated that he has
seen the feeble voice of his brother Rabindra Swami. But the Law and Trial Court, my lord, in this regard, also, and he stated that he was not killed. He stated that not to be killed is not acceptable, my lord. Is not acceptable, my lord. These points also did not consider properly or nor also scanned properly by the Law and Trial Court, my lord. Then my respectful submission before the Honorable Court is, my lord, so far circumstance is concerned, the evidence of the PW number 4, my lord, Vijay Patnaik, is also reliable, my lord. That was also not taken into consider. That was not also given importance by the Law and Trial Court, my lord. Then my respectful submission. Please, I also draw the attention of the Honorable Court. So for my ground, that is the page 15 para P is concerned. Please make a glance. I draw the attention of the last para, my lord. That is last before the last para. Further, the Law and Trial Judge acted illegally in not attaching due importance to the evidence of the investigation officer, PW number 16, to the effect that in the plain paper, FR, even though the name of the accused persons are there, but in the formal affair, the accused persons were so to be unknown. The PW 16 further stated that till the inquest was over, there was no clue with him about the real assailants of the deceased persons. Therefore, the Law and Trial Court held that the case was subsequently looked up for some ulterior reason, my lord. My lord, one thing is that the one duty of the prosecution as a getter thing to prove the case, my lord. But my respectful submission, so far the circumstance evidence is concerned. If the circumstance evidence is based on surmise, conjecture, and if that surmise and conjecture cannot be proved or place the conviction, cannot be proved the case for conviction, my lord. My respectful submission with due diligence regarding the circumstantial evidence, I am relaying also another decision, my lord.
Sir, there are too many decisions on that. We don't need to multiply. There are several decisions on that.
So I humbly submit, my lord. I'll file a sort of written order argument along with the
Correct. All right. Anyone else in this batch?
Yes. Before I proceed with my argument, Your Lordship, my Lordship kindly see the last order dated 17/8/2020. A report was called for by this Honorable Court with regard to the whereabouts of the appellants. If anybody survives, my Lordship, I will proceed with the case. Otherwise, that has to be seen, Your Lordship, because they are all aged persons. That has to be seen. A report is there with Your Lordship.
What's the report? Which is the appeal you are appearing in?
I'm for appeal number 4, Your Lordship.
In the same 259?
Yes, Your Lordship.
It is Balabhadra Swine?
Yes, Your Lordship.
Last occasion I had submitted before Lordship. Udayanath Pradhan has died.
Only one?
No, Udayanath Pradhan has died.
No, Balabhadra Swine is around.
In criminal, in CRLA 227.
No, we are in 259. We are in CRA 259. There is a report.
No, this is something.
There is a report.
So that's fine. Yes.
Report.
So there was 259, my lords.
Keshadev Swine.
They're all, yes, my lord. Keshadev Swine, appellant is alive and presently has been residing at Dubai. His contact number is so and so, but his family members have been residing at the evergreen address. The other accomplices, namely Pagar alias Niranjan Rautre, Sanya Sasmal, Balabhadra Swine, Sudhakar Swine, Vasudev Rautre
They're
reported.
living in their villages.
Yeah,
Yes, yes.
respective villages and its periphery.
So my learned senior has already placed the facts. I will just go through the order, the judgment, Your Lordship. My lordship may kindly see page number 25 of the paper book.
Yes.
It is with regard to the seizure made by the police, your lordship. I'll just place paragraph 4.
Yes.
I am concerned with appendix number 4, only Badabhadra swine. Now, at 8 p.m. on 7991, he searched the house of accused Basudev Rautarai in presence of witnesses and seized one old dirty 5 cubits, long khurda gamcha, one check lungi, and one striped towel, all suspected to have been sustained with blood. This is with regard to Basudev Rautarai. Now, Sesidev swine, 4.1. At 9 p.m. on the same day, he seized one black-colored old polyester lungi, one check old dirty towel, and one check striped old red-colored towel, all suspected to have stained with blood from the house of Sesidev swine. This is my lordship appellant number 1. Now, appellant number 3. On the same day at 10 p.m.
Yes, you don't have to read it. So basically, what you're trying to say is
because the weapon and as well as the stained cloths were only recovered from these 4 appellants. I am concerned with appellant number 4 as a Badabhadra swine. Nothing has been recovered from him. Just because of the enmity and to seek personal revenge, he has been entangled in this litigation. I should kindly see that. That's why I'm placing this. Nothing has been recovered from no weapon, no motive. Nothing has been recovered from the appellant number 4.
Not no motive, no object.
I apologize, Your Lordship. But my only ground submission is, Your Lordship, when nothing has been recovered from him, thus because of the rivalry between the villagers has been entangled.
All right.
Yes. My lordship will see the entire judgment.
No. When PW1, the informant says that he saw them coming down with bloodstained weapons, he does not mention you.
He has only said that I was there with holding a lathi.
Let's see that. So it's not as if there is no evidence against you.
No, my lordship. That's the circumstantial evidence because.
No, the whole case is only circumstantial evidence.
Yes, Your Lordship. And apart from that, nobody else has deposed that I have been entangled in that litigation.
No. Anyway, there is enmity between 2 groups.
Yes, Your Lordship.
So that doesn't carry you much further.
That will go both ways, Your Lordship.
That's right.
I will also file a brief sort of submission, Your Lordship.
All right.
My lordship, can you consider this aspect?
All right.
Yes, Your Lordship.
All right. Anyone else?
I am for appellant number 2, my lord.
2.
Pagola alias Niranjan Rautre. My lord, the lordship kindly have a glance to the judgment. I think it's paragraph
11, right.
11, my lord. It is reflected that admittedly, there is no eyewitness to the occurrence.
Correct.
Therefore, the prosecution case is built on around certain items of circumstantial evidence to prove its case against the accused person. Before the circumstantial evidence adduced and available on record are indemnized and discussed threadbare. It would be profitable to look into the certain judicial pronouncement of it. It rests on circumstantial evidence only. That there is no eyewitness to the entire occurrence, my lord. My lord, it is alleged that the petition, the appellant number 2 was coming with a sword in his hand, but the said sword has not been seized. In this case, only the wearing apparels of the present appellant was seized, and another appellant, namely Sasa Devaswamy, having volunteered to give discovery of a MO1, that is Kotari, which is concealed in the mango top of one Uchava Samantra on 19/9/91, while he was in police custody. Then the injury, that is the report, also, my lord. The injuries were all possible by heavy, sharp cutting weapons like MO1, but not by sword, my lord. That appellant number 2 was coming with a sword, as it is stated by the other witnesses. The MO1 weapon offense has not been seized. And there was a deep-seated village faction going on enmity between the members of the prosecution party and the members of the accused party. The accused persons in a meeting held in the house of one of that Jadumani Swine on 1991 decided to eliminate both the deceased. The aforesaid Jadumani Swine, in whose residence the meeting was held, has not been examined. Jadumani Swine. Although in his residence there was a meeting with convent relating to eliminate the two accused deceased, the prosecution was silent about his presence in the aforesaid meeting. And the first 6 accused persons were seen going towards Chhaka Singh at about the Bhaler Hill by PW3, the Rajkishore Balyar Singh, sometimes prior to 3:30 p.m. on the date of occurrence, armed with a lathi, sword and kati, sword and a lathi. But at paragraph 3 of this evidence, hardly we had gone about 150 cubits from a brinjal field of above the hill. We heard a sound making interally not to kill him. We stopped there for some time to know thing for certain. Golek told me, PW1 told me that the voice which we heard referable that of his brother Robbie, the deceased. But in paragraph 4 of his cross-examination, he has stated that I had not asked the above named 6 accused persons as to where they were going to. When I said them. At paragraph 4 of his cross-examination, he stated that I have not invited the attention of Bajayajani when I saw the accused persons going up above. They were armed with lethal weapons. I had not suspected the conduct of the above named 6 accused persons when I found them going armed with deadly weapons. At paragraph 5 in paragraph 6 of his cross-examination, PW3 has stated that I was not very sure about the death of Kubera and Robbie because I had not seen their dead bodies. We made no attempt to go to the Bilari Hill to search for Robbie and Kubera.
So what is your submission?
Yes, ma'am.
What is your submission?
My submission is that this appellant is no way involved with the accusations as alleged against him.
All right.
He may be acquitted.
Okay.
And he is in custody for more than 14 years, my lord.
All right. Yes, he got bail after 14 years. He's in bail or he's still in jail?
Bail, ma'am.
He's on bail. I think all of them are on bail.
Yes, all of them. Almost, my lord, 26 accused stood trial.
How many have got convicted?
6 were convicted. The first 6 were convicted. So the fact that all of them have been falsely implicated and there's a...
So in those 6, he says only from 3 recoveries were made. That's his point.
But there's the PW1.
All of them are shown climbing the hill and coming back.
They have gone, preceding the incident, they have gone. They have come down from the hill as they've been seen with the armed weapons.
Correct.
Though no eyewitnesses there, but there are enough circumstantial evidence to
show that 6 people went up.
Yes.
All right.
It's a double murder, my lord. And there's an extrajudicial confession which they did not come forth.
Anyway, in your turn, you can please. So it will be on board. So let Mr. Who's appearing for the other 3?
Perhaps Mr. DP Dhada.
Your Lordship, Senior is appearing for appellant number 3, 5, and 6.
Senior DP Dhada.
Your Lordship.
1, 5, and 6. I think Mr. Panigrahi appeared for 3.
3, 5, and 6. 3, 5, and 6, Mr.
No, Mr. Panigrahi appeared for whom?
1 and 3, my lord.
1 and 3.
1 and 3.
For appellant number 2.
2 and he was for 4. So only 5 and 6 are left.
Yes, sir.
All right. It will be on board then.
Yes, ma'am. Then I'll continue with my agreement.
Yeah. All right. So we'll rise now.
Yes, ma'am.